Romeo Johnson was once at the center of a very serious murder case out of Beaumont, Texas, accused of killing 57-year-old Ronald Barnes inside his own home. Prosecutors painted a picture of a targeted attack. They pointed to surveillance footage, phone data, and Johnson's connection with the co-defendant, arguing that he was involved in the events leading up to Barnes' death. But there was a problem. None of it directly proved that he was the man who pulled the trigger. No DNA, no eyewitnesses, no clear moment tying him to the act itself. And while many walked away from that trial believing that Johnson likely knew more, maybe even believing he was responsible, the courtroom operates on a higher standard. Suspicion isn't enough. Belief isn't enough. The jury's job is proof beyond a reasonable doubt. The defense leaned into that gap, and after just a few hours of deliberation, the jury delivered a verdict. Not guilty. But that wasn't the end of this story, because now prosecutors are back, armed with what they learned the first time around, and Romeo Johnson is facing a new charge tied to the same case. So you have to ask, is this about new evidence and finally closing the gap? Or is it something else? A second path to hold someone accountable when the first path didn't stick? Either way, this next trial could reshape everything that we thought we knew. And before a single juror is seated to hear that case, there's a process that most of us never get to see. We start with jury selection, voir dire, followed by motions in limine, where the attorneys will fight over what evidence the jury will and won't be able to hear. You'll even see moments of testimony outside the jury's presence, decisions made behind the scenes that can shape the entire outcome before opening statements ever begin. Before we get into this, I'm going to back up a few months. In February, he appeared in front of Judge West for a pretrial on this case. You can find the whole video on a channel called Courtroom Update, and I've linked it in the description. Let's get into it.
One of the pieces of evidence I want to introduce is a surveillance video that was introduced during the murder trial. The court will recall that this defendant was found not guilty in, and that the surveillance video shows what appears to be the defendant in possession of a firearm. The sponsoring witness of that video is out of the country and will be out of the country for a month. Under Rule 804 of the Texas Rules of Evidence, I believe the state can use the prior testimony of that sponsoring witness because it was subject to cross-examination by defense counsel. We have secured a transcript of that witness's testimony. We provide a copy of that transcript to Mr. Wilkerson, and if the court will allow us to use that transcript, then there's no need for continuance, and we'd be ready to proceed with trial.
Your Honor, I didn't come prepared to argue that this is the first I'm learning of that unavailability unless Mr. Coleman sent me something yesterday.
I don't see anything. There was I guess, just recently filed a notice of intent to introduce transcribed testimony.
I did file that, Judge, with regard to not only the surveillance video, but also with regard to the defendant's own testimony as well. The court will call you to the stand and essentially admit to possessing a firearm.
Which murder trial was that? Remind me what I'm...
Romeo Johnson murder trial. It was the victim was one of the twin brothers, Ronald Barnes.
Yeah. Oh, yeah.
Okay. You recall the brother was in the wheelchair that testified on behalf. With regard to this.
Give me just a second.
Ronald and Donald Barnes.
Yeah.
And Judge, I know you're reading, but Mr. Freeze or Judge Freeze did tell me to let you know we're in a 2-day trial.
No. Take me just a second.
Yes, Your Honor.
I don't know that this would...
My interpretation.
I mean, under 5, so 804A5.
804B, I think is what I'm...
Well, first is A is the criteria for being unavailable.
Sure.
So a declarant's considered to be unavailable if. So you've got to get one of those 5 to be unavailable. Then you go to B. So it's not 1, 2, 3, or 4. So 5 would be the only one possibly. It states that is absent from the trial or hearing, and the statement's proponent has not been able by process or other reasonable means to procure the declarant's attendance or testimony.
And that is what we're hanging our hat on, Judge. My investigator, Mr. Bass, is here to testify on the efforts that the state has endeavored in to secure the presence of the sponsored witness.
Okay.
I represent to the court that we've been unable, despite our best efforts, to secure the presence of that witness, given the fact that he's out of the country.
And so, all right, so we'll, if we're gonna get into that, we'll wait and do it at another time. I'll either lunch or like tomorrow morning or something.
Yes.
Because I need to set, this is probably, it's only, we're down to maybe 2 cases. So I will need to make that decision in a number of the cases. So let's do this, because I would need to hear that information. I think I want to look up a little case law just to make sure. And so you've got one witness?
No witness at all, Judge.
No, one witness that's unavailable.
Yes.
And that witness would be sponsor.
The surveillance video that purportedly shows the defendant possessing the firearm.
And then
And the other piece of evidence would be the defendant's own testimony. For planning purposes, Judge, I suspect this trial, it's the state's portion of the trial.
I just feel like without reading that, and I've never had this come up, where in his own trial, introducing testimony seems to violate the Fifth Amendment to me.
I don't follow this.
Well, I mean, it's almost like you're forcing him to testify by putting on prior. I don't know. Let me look into that.
Statement by party opponent, Judge. I mean, he's admitted from the stand under.
I just need to do some research that if it's I know if it's another party potentially, it talks about when it's a criminal case, what's given as a witness at a trial or hearing of the current or a different proceeding and is now offered against a party.
I mean, he very well could have asserted his Fifth Amendment right during that trial, and he did not, Judge.
Okay, let me look into that. You look into that as well. So 804, it looks like we've got 2 things. One is under A with regard to the unavailable
Yes, Your Honor.
witness. The other is under B, which is the former testimony of your client. So let's, I'll give you an opportunity. About how long do you think you guys will be going?
We anticipate finishing this afternoon, Judge. I could come back on the lunch break, or
No. You're in the middle of a trial. I don't want you to have to think about this and do that. I will number the cases tomorrow morning. So let's take care of this. Are you available to come? It won't take long. That gives me some time this afternoon to also do a little research.
I've got another case in the 317th, oddly enough, but I think I can kind of delay that.
If you can come here first.
Yes, Your Honor.
It won't take us longer than, it'll take 15 minutes. I mean, there's really, I'm assuming you're investigator, it will be quick to, testimony as to the unavailability. The other is just legal issues that we all need to just look into.
I'll ask for a trade out since I couldn't
Perfect.
stay here today.
All right, so head back down there. We'll get you back over here tomorrow morning, 9 o'clock.
All right, thank you,
Okay,
Judge.
sounds good. And if everybody gets here a little early, we can start early. I'll try to be here early as well. All right, go back with the bailiff. We'll see you tomorrow.
Come back tomorrow?
Yes, sir. You'll come back tomorrow, and that way we know what's going on for sure if you're going to trial or not.
Compliment you on your ability to not go off on the defendant this morning right out of the gate. That sovereign, I don't know if he's a sovereign citizen or whatever. Again,
He's just a wannabe.
Yeah, judicial temperament.
I appreciate that.
I wouldn't do short. Okay.
It's right there.
They test that temperament.
You understood.
You know what, though? We decided after court that that's actually better than understanding. I mean, there should be no miscommunication or anything like that, misunderstanding. If you, because you overstood.
Understanding.
Right. Okay, let's go on the record. Mr. Coleman and Mr. Wilkerson are here. And sir, you're Romeo Johnson?
Yes, Your Honor.
And so, Mr. Coleman, Mr. Wilkerson, are you both ready to proceed with trial?
State's right there. That's right here.
And we are going forward in 25 DCCR 1626, the unlawful possession of a firearm by felon, correct?
Yes, Your Honor.
And are there any motions? I know there were some issues we had before where we were ready for trial. And there was some request to use the transcribed testimony of the defendant. And then there was another witness who was out of town. Any issues?
I think that's not the case this time around, Judge. I did file a standard motion in limine. The only thing I'd like to add to that motion in limine is any reference to the acquittal or not guilty verdict in the murder trial.
Your Honor, the testimony.
Hold on just a second. You guys are free to go. Thank you.
Thank you, Your Honor.
Your Honor, the testimony that he seeks to introduce is directly from that trial. The jury not only deserves, but is entitled to the context in which that testimony was provided, as well as the outcome.
That's my brother.
I don't know about the outcome. I don't think that is relevant. I think that would be, I don't see how, if it were either way.
It's relevant to motivations for the underlying charge here, Judge. And if the court recalls, we have a motion for speedy trial filed on the aggravated robbery case, which we're going to be seeking to dismiss if we are moving forward on this case, because obviously if the aggravated robbery were tried and he was acquitted, he would be able to make bond on this charge. Whereas if he's acquitted on this charge, he will remain in custody.
So let's take that up at the appropriate time, which will be as soon as this trial's over. So we'll move forward with the unlawful possession of a firearm by felon. If he, depending on the outcome of that, I would anticipate that something would happen very quickly with regard to that aggravated robbery. If not, I would obviously consider a bond reduction based on all of that. I do think, though, so you still intend, Mr. Coleman, I want to make sure that the testimony that you are intending to introduce from that prior trial, you're still intending to do that, correct?
Yes, ma'am.
Okay.
Carving out any reference to a murder, my plan is to refer to that proceeding as a prior proceeding. I don't know. I'm open to any suggestions from the court. How to refer to
So
that.
my position is going to be that we are not getting into going down the rabbit hole of what that was, and for sure not what the final verdict was in that case. I don't see how that would help do anything other than potentially prejudice this jury.
Just for record purposes, regarding
Yeah.
that prejudice, Your Honor, the introduction of the testimony from that case by referring to it to a prior proceeding, especially when testimony is being used as an admission of guilt, is in and of itself prejudicial. So I understand your ruling and we will abide by it, Judge, but obviously our assertion is the complete opposite.
Sure. And
And we also believe that this case was motivated by the acquittal and intended to show such, Your Honor.
this case being,
The unlawful possession of a firearm by a felon, as this case was not filed.
well, I mean, I'm not going to get into what the state's theory or reasoning to file whatever they filed. They have filed it. It was indicted by a grand jury, set for trial. We're going to trial. We are going to go to trial on that unlawful possession, and immediately at the end, depending on the outcome, bring back up any issues with regard to the older aggravated robbery. We'll get that taken care of at that time. And I'll hear any motions on that. With regard to the notice of intent to introduce the transcribed testimony, we kind of went through that before, I believe, when we were set to go, and then I don't remember exactly what happened, but we didn't go to trial. And my interpretation of 804, I think it's B1B. Anyway, I believe Mr. Coleman is entitled to introduce that. It was from the same criminal episode. So it's not some testimony, sometimes from some other case that has nothing to do with these particular facts. And so for that reason, I am going to allow that testimony, the transcribed testimony. It is only going to be limited, however, to the prior hearing, and not that it was in a murder trial, and not that it was for sure an acquittal in that murder trial.
And
Mr.
just,
Coleman.
I am referring to the excerpt, and it's just an excerpt from my questioning of the defendant. It's like it's 6-page excerpt, yes. And I'm happy to give it to the court if you want to preview it afterwards or during a break. But it's just an excerpt of me essentially asking him about the firearm.
Okay.
Your Honor,
Yes.
I'm trying to understand why, when a defendant testifies, the state can examine that defendant about their criminal history, but that if a defendant testifies on his own behalf, he can't talk about his criminal history.
If your client chooses to take the stand in this case, then I would think there would be probably different, and that he can say that he was charged with something, but it's not a conviction. And at that time, I think I would want to take that up before that question is asked, and let me kind of think about it and do a little more research on it. Because if somebody's been charged with something, acquitted of it, again, how does that then become relevant or help this jury determine guilt or innocence, is what my thought process is going to be. I'm not going to prejudge that right now, but I am saying right now, before either of you question any witness about the prior trial that ended up in the acquittal, you approach the bench and we discuss it outside the presence of the jury, regardless of any motion in limine. I'm making that order at this time.
I'm sorry, go ahead.
I'm sorry. I would note, Judge, just finally on that matter, that in terms of the state being able to use uncharged offenses that have not, where no guilt has been determined, both in guilt innocence as impeachment evidence, if the jury finds beyond a reasonable doubt that that act actually took place, and the state's ability to introduce testimony on uncharged acts and omissions during punishment, that again, it would re-urge the question that
Again, I'll take it up at that time to see but they're not just allowed to do that without certain findings by the court, certain requirements as to why they are admissible. And so the same, I think, would apply as to the relevancy of it. And we would get to that if, in fact, he decides to take the stand in this trial. I would have to decide that at that point. But they don't always get to do that, depending on what it is going to show: motive, intent, preparation, identification, and all of those laundry list of things. And it doesn't always have one that applies.
and again, I
Right.
think I'm referencing a defendant's own testimony more so than the enumerated reasons for allowing other extraneous acts into evidence. But those used for impeachment purposes, as far as the witness's credibility. And so,
Well, I mean, but the state's never, not that I know, has the state been able to go into something that for credibility or impeachment for a charge that was either charged and dismissed or charged and acquitted, certain specific instances of some type of behavior maybe could become relevant and admissible. But if it's almost the negative here. There isn't one. It was charged and it's gone. It was acquitted. And so that's, I guess, it's kind of
And I just want to put a point on that, Judge, is with regard to the murder, that's a whole separate offense with separate elements. We are proceeding on a new offense with separate elements, Judge, and the potential here is not only to confuse the jury, but also to open the door and allow improper argument. That argument being, because he was acquitted of this, he should be acquitted of, because he was acquitted of that, he should be acquitted of this as well.
which is the exact same thing when it's the other way around. You can't say he must be guilty of this because he already did that. So we don't allow the state to do that. And so I don't think it's fair to do the opposite of that, if that makes sense.
I think no, that makes sense. And I think where it'll become relevant is if the defendant takes the stand and there's some sort of use of prior bad acts to impeach his credibility as a witness. And so,
Well, yeah,
I guess
but
we'll
if those,
cross that bridge when
yes,
we come
we
to
will.
it.
But I want to know, so before, if he is going to testify, then we're going to take some time, because I'm going to want to know exactly what potential bad acts. It's not going to be the murder. The murder was acquitted. So to me, for all purposes, the murder is outside the scope of whatever is going on here, other than the fact that it's that same, again, criminal episode. He testified, made some potential admissions that I believe and have already made a ruling are admissible in this case. But we're not going to get into the confusing part of the acquittal and use that to potentially try to sway a jury to say he was found not guilty of that by another jury. So this jury should do something in line with that on this case. So
I don't anticipate ever making such an argument, first of all, but I do anticipate introducing testimony from the defendant and as to the fortuity of the alleged possession of a firearm in this case, which again was that testimony was provided and tied to an examination of the witness based on the allegations at that time. But again, I understand the court's
okay. All right.
One final thing, if I may, Judge.
Yeah.
Just so we're all on the same page. Are we referring to that prior case, the prior trial, as a prior court proceeding? That's
Yes.
what I'd like to refer to it.
Hearing or court proceeding,
Okay.
either one. I think those could be used interchangeably. If you accidentally say hearing, it's fine. Court proceeding is fine. Trial, not fine. And trial of murder, definitely not fine. So with regard then to the state's motion in limine that has been on file, Mr. Wilkerson, have you had an opportunity to review that?
I have,
Standard,
and
do you have any
it's pretty
objection?
standard. The only other one that I find objectionable is the one that we pretty much discussed. It's at the bottom of the second page. Additionally, there may be some evidence introduced of another pending charge, but I guess we'll have to deal with that at the same time as well. Because, I mean,
I think he's talking about the aggravated robbery.
yes, yep.
In the guilt innocence, do you anticipate that being an issue at all?
No.
Okay,
No.
so there's no reason for that to be brought up in the guilt innocence. Now, if the defendant takes the stand, we can take that up outside the presence. It sounds like if the defendant chooses to take the stand, we'll obviously need to kind of regroup with regard to any other witnesses in the guilt innocence. I don't see anything that would make me feel like any talk about the aggravated robbery, definitely that underlying murder case that was acquitted, anything not
convicted. It is an unlawful possession of a firearm by a felon. So obviously the fact that he's been convicted of a prior felony is relevant. So we can't get around that with this type of case. So that obviously is jurisdictional, and the state will be required to prove that in the trial for guilt innocence, which is a little bit unusual, but required in this one. Other than that, anything else then? I'm going to grant the state's motion in limine, in addition to what I've kind of ruled on with regard to discussing that prior trial, and anything that you think becomes potentially relevant or admissible, approach the bench first if you think some door's been opened or something like that.
Before we start, I need some instruction on the questioning of the detective. Because one of the questions that I intend to ask is the nature of the investigation. So essentially you're telling me I can't ask him about the nature of the underlying investigation. How do I talk to him about when this case was finally indicted versus when it was investigated? And then along those lines, why it was investigated?
May I propose that, and of course, the court can make the ruling the court decides to make, but I mean, certainly he can ask the detective if there was an ongoing criminal investigation. I don't have a problem with that. Whether or not this defendant was subject to a criminal investigation. It's just a reference to the murder and any reference to an acquittal.
So he has no problem. Essentially, this is what I'm hearing. You can say that there was an ongoing criminal investigation. You just can't talk about the fact that he was acquitted in that investigation.
Correct.
Yeah, you're the one that's wanting to ask him about the nature of his investigation, and I will concede. I don't see a problem with you asking him whether or not there's an ongoing criminal investigation.
I don't either. But here's the thing: what's not going to come in is the outcome of that trial. So if you want to question, I think it's fair. I don't disagree that it's relevant potentially that why they were investigating, and they were investigating a murder. They were investigating an aggravated robbery. But I'm also not going to allow you to go down the path very far of what's the outcome of that and what's happened. We're here on this case. Those cases, just like I would tell any jury, are set for another day, another time, another jury. That's not what we're here for.
Can I talk about the fact that a different defendant was charged with that underlying investigation?
I just don't think that becomes relevant or helpful for the jury. My ultimate question, obviously, on relevance is how will that help this jury determine if this defendant is guilty of unlawful possession of a firearm by a felon? And so it's going to be very limited on how far I allow you to go down that path. Talking about co-defendants and what they were charged with and what's happened on those cases doesn't matter. If it was the murder case and there's a co-defendant to the murder, absolutely. But it's not. That's not what we're here for. It's a very limited requirement as far as the indictment is what it is. Whether he was in possession of a firearm is the question. And muddling it up too much with all the history is not going to help this jury. So I guess that was a long way to answer no. We're not going to talk about the co-defendant and what anybody was charged with. You can talk about that they were conducting an investigation.
But
and in the process of that investigation, I mean, by the time you're questioning him, my guess is the video is already going to be in. They're going to already have seen the video of what happened and in person, and so what we're talking about, just because I've obviously seen it in that trial, is on video. And so the jury will have already seen that. And so going down any other path very far, other than saying either you did or didn't see what you saw, or what was on the video, you interpret the video however you interpret the video, whether or not he possessed a firearm or didn't. There's going to be the testimony that he gave previously. And so I think that limits it.
Mr. Wilkerson also mentioned the timing of how the charges and when the charges were found. I would object to that, Judge, just as long as it's within the statute of limitations. And that should have been the subject of some form of a motion to suppress. So,
no. So the indictment that's going to be read to the jury talks about when the indictment occurred. Obviously, it also talks about
the date of the indictment.
No. In the term assembled.
Right.
I have no objection to that, Judge. And
so I should at minimum have a right to cite the portion of the indictment that talks about when it was indicted versus when it was investigated or committed.
I don't necessarily have an objection to that so much as there an argument that for whatever reason there's some nefarious or malintent on the part of the state judge.
Well, because we're not going to get into the murder and the outcome of that murder, it again does not. I understand where you're going with this. They didn't get a guilty in one, so now they're going to file something else. How's that going to help this jury knowing that?
Knowing that The offense.
How does it help them determine if he's guilty or not guilty of this charge? If you're trying to get into, well, they didn't, it didn't work on one, so they're trying something
It
different.
showed whether the prosecution believed that there were grounds for this charge in the first place, Your Honor.
That we routinely exercise prosecutorial discretion in bringing charges, and we make that call all the time, Judge.
And
Well, and that's a call. I guess the issue with that, I don't know that the detective had the ability. He didn't make that call. It was the state that took it to the grand jury, and
We exercise our prosecutorial discretion in this case, like we do in many, many other cases, Judge.
but how does the detective testify to that? I guess is if
all I can elicit from the detective, and all I intend to elicit from the detective, is the date of the underlying occurrence and when it was indicted.
No objection.
Now, in terms of argument, citing that date, the delay, and the recent indictment of a case, I mean, that's something that.
I mean, you can argue the dates, but not argue. We're not going to again get into, well, they didn't get it. You're not going to be able to bring up. We're not talking about the murder, and the acquittal in the murder. So knowing that, I guess you limit yourself to whatever argument you can make on that, because I just don't see how that is relevant to helping this jury determine guilt or innocence of this particular offense.
Whether or not a grand jury that considered the occurrences in the prior, in this.
We don't know what a grand jury looked at, and we're not able to know. So we don't know what was presented the first time around. We don't know that. I don't think. I mean, we're not going to have a grand jury here to question, and the detective sure isn't going to be able to answer that question.
Obviously,
from a grand jury.
There had to be an allegation of possession of a firearm in order to.
But that's an assumption.
So
yes, I agree that at some point there was, but I don't know. We don't know what the grand jury, why they did what they did, why the state did what they did. And I don't think it's relevant to this jury really to know those things. I don't think it helps them to determine the guilt or innocence of. I mean, you can be unhappy about why it got to this point. I get that. I understand your reasoning and the frustration, but the charge is what the charge is. If it's either guilty or not guilty of this charge, fair or feeling or not fair feeling to you and your client, it's what the grand jury indicted him for. And we're going to limit it to what will help them make that decision in this case.
So can I ask the detective why he thinks it took so long?
That would be pure speculation on the part of it.
I mean, you can ask it if he objects at that point based on whatever evidence has come in. I'm not going to prejudge that. So, I mean, ask the question and then if there's an objection, I'll determine based on what I've heard at that point, whether or not I would rule.
I just don't think it would be speculation for him to answer.
Well, we'll get to that at that point.
Thank you.
All right. So then again, I'm granting that motion. Anything else before we get the jury seated?
I'm from State Judge. As far as time, I can't imagine more than 30 minutes. Pretty good.
Okay.
Could,
Thank Mr. Wilkerson.
warning.
You're fine with that?
Yes.
What warning to 5 minutes?
Yes. that's
Okay. A difference on whether or not we can do our job if you're here or not. And so we really do appreciate you because we cannot do our job without you. The first thing that I'm going to do, and you can all remain seated while I do this, is I'm going to give you an oath. So I'm going to ask if you would all please raise your right hand. Do you and each of you solemnly swear that you will true answers give to all questions propounded to you concerning your qualifications as a juror? So help you God. Thank you. And so all that means is that you promise to tell us the truth this afternoon. The process that we're going to go through is called voir dire, which just means to speak the truth. And what we will do by the end of today is have a jury selected that will serve for the next few days with us. We don't anticipate the trial this week lasting longer than a few days. And so we just need you to be able to be here for this week. Used to, if you were on a jury panel, excuse me, probably pre-COVID, pre-COVID, we used to have you go down to that jury paneling room downstairs, and then a judge would come down there and qualify a big, huge group of you, and then you would get sent to the courtrooms. What we have now with iJury, I think, is a whole lot better because at least you don't have that process that you have to sit through and then get sent to a court. But also what that means is that I need to go through with you what the qualifications are to be a juror. And then I'm going to ask all of you if any of you think that any of those qualifications might apply to you. And if you do think so, we'll have you come up individually and we'll discuss that to see if you are in fact qualified to sit on the jury. So the first qualification is that you have to be 18 years of age or older. You have to live in Jefferson County. And so we need Jefferson County to be your permanent address this week. If you have moved permanently outside of Jefferson County before you came today, we need to know that. If you plan on moving next week, you're good. We just need you to be a permanent citizen this week. You must be of sound mind and good moral character. I'd like to assume that all of you who showed up to do your civic duty probably meet that criteria. You must be able to read and write the English language. If you have served on a jury, so not just this process, but if you were actually on a jury in the last 6 months, and the trial that you were sitting on lasted into the second week, let us know that, and you could get a pass this week. If you, again, last 6 months on a jury that went into 2 weeks. You cannot have been convicted of felony of any kind or a theft of any level. You also cannot be under legal accusation or indictment for a felony or a theft of any level. And so that's really it for the qualifications. And so what I'm going to do now is just go kind of row by row and ask by a show of your hands if any of you believe that any of those might affect you. And so I'll start on the front row, kind of coming across this side. Is there anybody on the front row by show of hands that think one of those qualifications might apply to them? Coming across the front row this way. Second row coming across that way. Second row coming here. Third row going all the way across third row. And then the last row. Is there anyone in the last row that thinks they may not be qualified? Great. So for your service today, you are going to receive a whopping $20. Contain your excitement. After today, if you get on the jury, you receive, it's $58 a day after today. I know that that is not meant to compensate your time. Obviously, your time is much more valuable than that. It's just what the state of Texas gives, kind of as a token of appreciation. You're obviously welcome to keep it, take yourself to dinner. That's about all it'll pay for nowadays, maybe, on a good day. Or you can also donate that through that iJury system. There's 2 different funds that you can donate it to. One is the Compensation to Victims of Crime Fund, and then the other is the Children's Welfare Service Fund. Both of those help people locally who've been affected in the criminal justice, either by a victim or things like that. So before we go forward, at this point, I'm going to stop for a second, let the court reporter, she's going to come sit down there closer to y'all so she can hear everything we're doing now that we've gotten past that. So obviously, with the court reporter moving down there, you all know, and those of you who've been through this before, know that she is not just taking down everything that I say or that the lawyers say this afternoon, but everything that you all say also. And so it's going to be very important if you're called on to answer a question that you please speak loudly and clearly so we can all hear you. And also we'll be calling you by your name, your juror number, so the record can be as clear as possible, kind of who's talking at what time. I understand and the attorneys understand that public speaking is not everyone's favorite thing to do. If there is a question that is asked of you that you are not comfortable answering in front of 59 or 60 of your new best friends, all you have to do is say so. At the end of this process, we'll take a break and I'll have all of you leave the courtroom. And if we need to talk to anybody after, we'll bring you guys in one at a time. So what we don't want is for you to have some information that could affect your ability to be fair in this case and you not tell us. And then we get into the trial and we're a day or two going down the road and you say, I should have said this and you didn't, and it could potentially cause a mistrial. And we would have to do this all over again. And we don't want to have to do that. Everyone has personal experiences. The reason for this process is because everybody has personal experiences that could affect their ability to be fair in any given type of case. Everybody's not set out to be a juror or made out to be a juror on every kind of case. And so that's what the lawyers really want to know. They want to get to know you, get to know how you feel about certain offenses and things like that. And so that we can get as fair a jury as possible. An example I give is that let's assume that you went to dinner last night and when you came home, your house had been burglarized and ransacked and precious, irreplaceable items had been stolen. And you show up the next day for jury duty and it's a burglary of a habitation case. It may be a little soon for you to be fair on that kind of case. You may say, you know what, I feel so victimized that I could never be fair if it were that type of case. Or you may be able to say, you know what, I can put that aside. I can take into consideration just what I'm given here in the courtroom and not let a personal experience influence your determination of guilt or innocence. So it really just depends on you. And that's why we need this chance to talk to you. We talk about this process being jury selection. It's really not a selection process. It's really a deselection process. And the way that works is that the lawyers each at the end of this process, after they've both talked to you, they have 10 strikes that they can use to strike any of you for just about any reason with some exceptions. And then after they do that, it's the first 12 and then we'll have an alternate. So 13 starting with number 1 and going down that way. So you guys in the first couple of rows are in the hot seat, depends on the back, kind of how things go. But that is really how the process works. So what I'm going to do, let's see, just go through what the case is that we're going to hear this week. I'm going to introduce the attorneys that are representing the state and the defendant. Then I'm also going to ask all of you if any of you know any of us and how you know us, and if that would make it to where you would not be able to be fair for some reason in this case. So the case that is going to be heard this week is cause number 25, DCCR 1626. It's styled the state of Texas versus Romeo R. Johnson, who's charged by indictment with the offense of unlawful possession of a firearm by a felon. The range of punishment provided by law for this offense is between 2 years and up to 10 years in prison and or a fine of up to $10,000. And so representing the state, we have Mr. Tommy Coleman.
Good afternoon, everyone.
And then representing the defendant, we have Mr. Marcus Wilkerson. And the defendant, Mr. Romeo Johnson. And so what I'll do is kind of what I did before. I'm going to go row by row and ask by a show of hands if any of you know any of us. And so I'll start here on the first row. Do any of you know any of us? No? All right. Second row. Anybody? I mean, first row, second side. Second row going across. Let's see. Is it Mr. Bishop? No. You're Mr. Bishop? So it's Mr. Bennett. You number 22, Mr. Bennett? And who do you know, sir? Okay. Is there anything about that would make you feel like you couldn't be fair in this case? Okay. Well, we might visit with you about that after. Anyone else? Second row. Let's see. And sir, are you Mr. Walker?
Yes.
Number 25. And who do you know, sir? You do? All right. So we'll talk to you about that also after docket or after this process. Let's see. Second row going further over. Third row. Well, hi there.
Howdy.
How are you, sir?
Doing great.
So we've got, that's number 32. Officer Bowman is in charge of security here at the courthouse, or one of them. And so Officer Bowman, you obviously know, or Deputy Bowman, you know everyone here, correct?
Yes.
Is there anything about any of us or your relationships with the attorneys or myself that would make you feel like you wouldn't be able to be fair in this case?
No.
Okay. And we may visit with you also in a second about that. Let's see. Third row coming back across this way, coming over here, third row. All right, back row. Anybody? And you're going to have to help me out with your number now. I've gotten out of order over here.
What?
Or what's your name?
Javier Cabanillas. I mean, I know who you guys are.
Number 53, Mr. Cabanillas. And who do you know, sir?
I know Mr. Wilkerson and I'm an attorney at Price Law Firm.
Is there anything about that? Thank you for coming. And is there anything about either of those relationships that would make you feel like you couldn't be fair in this case?
No, ma'am.
Thank you, sir. Anyone else on that back row that I missed? Okay, perfect. All right. See, it's not hard. It's not hard questions. So the process this afternoon also, and so let me see if I raise a hand. How many of any of you have been on a jury in here before and had to hear this spiel? I apologize. I knew I recognized some names. Some faces and some names. I need to change up my stories, I guess, for you guys that have to listen to it. But it is the same thing. So the process this afternoon can sometimes be a little bit frustrating because the lawyers are not allowed when they're talking to you to talk about the specific facts of this case. So they're going to talk to you in hypotheticals and generalities and may ask you questions that would make you first think, well, I don't know, because I don't know, the facts of the case. They're not doing that just to frustrate you, I promise. That is just the nature of how this works, and they're not allowed to do that. There are no wrong answers. We do not want you to try to answer something in a way that you think we want you to answer. We really need to know how you feel about certain things. That's the whole process. And so please don't try to answer something in a way because you think you might answer wrong. There isn't a right or wrong. It's all about your thoughts on whatever it is that the lawyers are talking about at that time. Let's see. So, well, real quick, Mr. Wilkerson, did you file a election?
It's jury, Your Honor.
Okay, we'll make sure and get that. So in any criminal case, there's two phases in that trial, potentially. The first phase is the guilt innocence phase. And then if there is a finding of guilt, there would be the punishment phase. And the defendant in any given criminal case has the right to choose or elect who punishes him if the jury finds him guilty. In this case, the defendant, Mr. Johnson, has elected that if he is found guilty, it would be the jury who would assess punishment. So that would then become your job if there's a finding of guilt. So we'll talk a little bit more. I'm sure the attorneys will talk a little bit more about that punishment range. I went through that kind of quickly at the beginning, but again, it's between 2 years and up to 10 years. There are times, depending on the trial, where punishment could be enhanced to something worse. There are times that it could be something less, but this offense, the range is 2 to 10, and without any other information, that's where we are on this case at this time. The most important thing about that punishment phase, if we get there, is that the jury can consider the entire punishment range. And the reason there's a range is because every case is different. Every defendant's different. Every set of circumstances and facts surrounding the case are different. And so the legislature gives juries or judges a range. So what they ask, or you have to be able to say as a juror, is that after you hear all the evidence in the guilt innocence phase, if you find the defendant guilty, that you would listen to any additional evidence that was given in the punishment phase and take all of that into consideration, talk to your fellow jurors about it, and consider the entire punishment range from the low end to the high end and get to a number with everybody else in those discussions. That's really all that's required, is that you consider it at this point, because you don't know anything. And so no one can say, would you give 2 years or would you give 10, because you don't know anything about the case. You just have to be able to consider it once you hear everything. You will have at the end of the trial a written document that's called the court's charge. It's a document that I provide to the jury that has all of the instructions, any legal terminology, definitions. It's kind of your playbook to go by to take the evidence that you hear in trial, put it together with the law that's provided and the instructions in that court's charge, and that's everything you need to come up with your decision. You are specifically instructed not to Google terms or look up anything. You don't need to have any knowledge about anything criminal or legal at all to be a juror, because you'll get everything you need here in the courtroom. I'm going to go through just a few kind of general legal principles that apply in all cases, and then I'm going to turn it over to the attorneys to visit with you. The first legal principle is the presumption of innocence. And our law provides that all persons are presumed innocent, and that no one may be convicted of an offense unless each and every element of that offense is proved beyond a reasonable doubt. The law does not require a defendant to prove his innocence or provide any evidence at all, because that presumption of evidence is sufficient to acquit the defendant unless the jurors are satisfied beyond a reasonable doubt of his guilt. So if you were to vote right now whether or not the defendant is guilty or not guilty, what would your vote be? Okay, I think I heard that right. What was it? There we go. Okay. So the law says that the prosecution or the state, in this case, Mr. Coleman, has the burden of proving the defendant guilty, and he must do that by proving each and every element of that offense beyond a reasonable doubt. And if he does not do that, then you must acquit the defendant. I've used now that term beyond a reasonable doubt a few times. Many years ago, there was actually a definition that was given to jurors as to what that meant. That, however, was abolished some time ago by the Supreme Court, that we are no longer allowed to define for you what beyond a reasonable doubt means. I think that kind of means two things. I think first, you decide for yourself what you think beyond a reasonable doubt is. And then second, you decide if the state has proved each and every element of the offense beyond a reasonable doubt. Now, there are other burdens and levels of proof. If you're in family court, they have one and they're able to define it for you. If you're in civil court, you can get one and they get to define it for you. Here, you don't get that definition, but it is the highest level of proof. And that's really pretty much all we can tell you. It's not 100%, but it's the highest level of proof that we have. Our law also provides that a defendant may choose to testify on his own behalf if he would like. However, that same law, as you all know, which is our Fifth Amendment right, he can elect not to testify. And if he chooses not to testify, you have to not consider that in any way. You cannot consider or discuss why he didn't testify, what he might have said, or anything like that. You can't use it as evidence of guilt against him. A lot of people, human nature, you want to hear from both sides. A lot of people say that I want to hear from both sides, but that's not how our system is set up. Our system is set up that the state has to prove it, and a defendant would choose not to testify for a number of reasons. Just like you guys, not everybody's a good public speaker. They talk to their attorneys. They're usually advised on that. But the main thing is that you would not say, well, he must be guilty because he didn't testify. Ultimately, that's what the law says. That's really kind of it for what the information is that I'm going to give to you today. The last thing I'm going to tell you, and also let me just tell you what, sometimes the attorneys may kind of lighten things up in here, tell some bad jokes, whatever. We do not want you to think that we don't think what goes on here is very, very important and serious, because every case we hear they're all felony cases in this courtroom. So they're all very serious. But the whole purpose of this process this afternoon is to kind of loosen everybody up so that you'll talk to the attorneys, have a conversation with them so they can get to know you. I stole this from an attorney. He's not here today, but a lot of times people think that if they're really quiet and they kind of sink down in their chairs and they don't say anything, that they're going to get to go home and not come back and sit in one of these special chairs over here. And it is the opposite. It is usually the quiet ones that get to come spend a few days with us. Again, mostly true, but also just a reason for you guys to kind of open up and talk to the attorneys. All right, so Mr. Coleman, you may proceed.
Thank you, Your Honor. Good afternoon, ladies and gentlemen. Again, my name is Tommy Coleman, one of the assistant district attorneys here in Jefferson County. For you folks in the back, if you're having a problem hearing me, just raise your hand and I'll do my best to speak a little louder, project a little more. I always feel like I'm yelling at these poor people in the first row in my attempts to make sure that you hear me way in the back there. Listen, I know there are other places you'd rather be. I know there are other things you'd rather do, but I know for me at least, and I suspect the same is true from you all, that if you were sitting where this defendant is sitting, you'd want people to show up and give 100% attention to the issues in the case, to the presentations of the attorney or attorneys in this case, and not be thinking about the grocery shopping you can get done, the things on your to-do list you can get done, or the work that's piling up on your desk. So, well, with that being said, I will make you a promise if you make me a promise. I promise I will limit my remarks to you as close to 30 minutes as I can. If you promise me that you will give me your full attention, that you will engage me in a back and forth discussion, and you will truthfully, honestly answer the questions that I ask you as it relates to this case. If I have that agreement, I'd ask you to raise your hand and show me you agree. All right, very good. We have an agreement. That's not fair. For the record, looks like just about everybody raised their hand. And for you guys, just so you know, I'm not talking to myself when I say stuff like that. I just want to make sure that it gets on the record. So from time to time, I'll be pointing some things out like that. I've read your jury questionnaires. I know a little bit about each and every one of you. Ms. Bridges, juror number 1, you're a florist, right? Yes. Juror number 4, Mr. Van Houten, you're a financial advisor, correct? Yes, sir. Mr. Cruz, juror number 20. UPS, no, United States Postal Service, right? That's right. Juror number 26, Mr. Bob. Yes, sir. All right. HEB, Sergeant Bowman, I know where you work. Yes, sir. Juror number 33, next to Mr. Bowman, you are retired from Valero, right? Correct. And juror number 50, did you carpool here today with anybody? Yes. Who'd you carpool here with today? Who happens to be sitting right next to you, right? Yes. I've never seen that.
Oh my gosh.
I've never seen that. And I've been doing this for a little while. All right. So we may circle back to that a little, because I would want to know if the two of you, I can imagine how they would, if the two of you were to end up on the jury together and you happen to disagree, how would that work? After you leave the courthouse, that's what I'm getting at. But my point is, I know a little bit about each and every one of you, so it's only fair to tell you a little bit about myself. I was born in the state of Texas, lived in the state of Texas all my life, but for the time I was in the United States Army. And after graduating from law school, I have essentially been a prosecutor for my entire career. And from time to time, I serve as a special federal prosecutor. I enjoy being a prosecutor. And contrary to what some people may think, Ms. Logan, you're number 6, being a prosecutor is not always about seeking conviction, not always about sending people to prison. It, by statute, Ms. Ramirez, it is by statute I am required to seek justice. And that's what I want for this defendant. I want justice for this defendant. I want justice for this defendant, and the way we get there is for me to select 12 of you, or for us to select 12 of you, Mr. Juror number 16, Mr. Bristol, 12 of you who will be fair and impartial and listen to the evidence in this case and render a verdict based on that evidence alone. Okay. The last thing I want you to do, like the judge mentioned, Mr. Gerard, number 23. Right? Yes. You're an electrician, right? Yes. The last thing I want you to do is try to give us an answer that you think I want to hear, or Mr. Wilkerson, or even the judge wants to hear. Now's the time to be honest. Ms. Bridges, juror number 1, you're a florist. If I were to ask you what is the prettiest flower out there, even though you know that I am a fan of an orchid of orchids, and I have like I'm the orchid fan club president, chapter president, and you know all that stuff about me. I have a t-shirt that says I love orchids. And I tell you, and I ask you, what is your favorite flower? If you don't think it's an orchid, I want you to tell me that. If you think it's a tulip, that's fine. If you think it's a rose, that's fine. Now's the time to tell me what your honest opinions are. Because once you're selected as a juror and you are sitting in that jury box, you are obligated to follow the law, Mr. Moman. Okay? Whether or not you like the law or not, you're obligated to follow the law at that point. Okay? Just out of curiosity, Ms. Bridges, how long have you been florist?
I've been one now for about 2 years.
Sorry. What is your favorite flower? Now I'll open it door. It's what?
It's called protea. It's an interesting flower from South Africa.
I will Google it. I will Google it after protea. Okay. But you see my point. What I'm getting at is now's the time to say it. I mean, and I'll give you another example. People disagree oftentimes. While this is not a drug case, Miss, who have I not talked to? Miss Loomis, 19? Lemus. Oh, it's a good point. If I mispronounce any of your names, please feel free to correct me. But Miss Lemus, juror number 19. Oftentimes in these drug cases, we get people in here who say, particularly with the marijuana case, oh, it's a stupid law. It should either be decriminalized or legalized. And again, that's fine if you believe that. It's okay. There won't be a trap door that opens up. You won't get tased by Mr. Savoy over there. Now's the time to tell us your honest opinions about the law. I think it's a stupid law. But for instance, using that marijuana example, once you get on that jury, and if I prove all the elements of my case in that marijuana possession case, and I prove them to you beyond a reasonable doubt, then you're obligated to follow that law, whether or not you like it or not. Does that make sense? Does anybody have any questions about it? Juror number 14, Miss, let me look at last name. Seta Tano. Wrote for BISD, right? All right, so does it make sense? You follow me? Give me your opinions now. I'll give you my opinion about something. If the legislature were to meet in the next session and outlaw bacon, make it a felony offense to consume bacon, I may as well turn myself in. I may as well go down to the jail and say, lock me up. I would think that's the stupidest law because I love bacon. I love orchids and I love bacon. So, all right, let me just move on. Remember, I deal 30 minutes. So let me move on down my outline here. While I cannot talk to you about the law or the specific facts in this case, I can say that this defendant is charged with being a unlawfully possessing a firearm while being a felon. And more specifically, that's found in chapter 46.04 of the Texas Penal Code. It states that if a person has been convicted of a felony offense, they cannot possess a firearm until after 5 years after their confinement ends or after their period of parole ends. And even after that, even after the 5 years, you can only possess it at your habitation. I'm looking at you, Mr. Belair, you're the one. Does that make sense to you? At least we'll get to whether you agree with it or not, but does the statute as I read it to you at least make sense? If you're a convicted felon, you are prohibited from possessing a firearm unless or until after 5 years, then you can possess that firearm at your residence, your habitation. What do you think about that, juror number 17? First question, Mr. Lugman, is why do you think the legislature would make that carve out for after 5 years of possessing it at your residence?
I would do it.
Yeah. Somebody help Mr. Lugman out. What anybody?
Protection.
For protection, exactly right. Who said that? Way back in the back, juror number, oh, my chart's got it. I got it right here. Bail, 49? All right, yeah, protection. Yeah. Those get it. We can get you on the next question there, Mr. Office. I'm sorry, I was coming to you, Ms. Bill, buzzed in before you. Yeah, presumably that's why they did it, is, after a certain period of time, 5 years, the legislature in its wisdom says that, at least for protection, I think that that's the reason. If for protection at your home, your residence, your habitation, you can have a firearm. But you're still prohibited, even after 5 years, from possessing that firearm anywhere else other than your residence. Juror number 9, Ms. Stevenson,
Yes.
worked for Port Arthur ISD. All right. What do you think about this law, Ms. Stevenson? It's fair. I mean, think about it. The legislature, they legislate a lot of behavior in society. In other words, you can't drive 60 miles an hour in the school zone. That's against the law. You can't marry a 13-year-old. That's against the law, Ms. Simi. Juror number 5. The legislature legislates a lot of behavior. Now I know that there are some Second Amendment folks out there. I just need to find you. I need you to raise your hand. Remember our deal? You give me your honest answers, your honest feedback. Otherwise, I'm just going to talk as long as the judge tells me to sit down. So, all right, there's one of them. Juror number 17. But what about my Second Amendment rights to carry a firearm? You're a felon, and that's the law. Again, you can have your opinion now while you're sitting out there, but once you're in that jury box, and if I prove the elements of this unlawful possession of a firearm by felon, your opinions, your personal feelings about it kind of go by the wayside because you're going to take an oath to follow the law. You're making it too easy for me, Mr. Levin. Somebody out there is saying, you know what? I want to go hunt deer. And I'm a convicted felon. I want to go hunt. I'm not a hunter. I mean, what else do you hunt? But this is Southeast Texas after all. And I want to go hunting. And just because I've been convicted of a felony, I shouldn't pay that high penalty. You had your hand up during number 16, Mr. Bristol.
Yes, you had your choice before, and you made your choice, and now there are consequences that must be attached to them.
Thank you, Mr. Bristol. Anybody else? You guys too easy. Somebody disagree with me. Somebody, juror number Maribel 24. Maribel, you have the most awesome job. You're the A manager or D manager at Rayos?
Oh, that's, yes.
He was. I couldn't have that job. There's no way. There's just too much temptation there. But my point is, come on, somebody has to think this is too heavy-handed by the legislature. Nope. There we go. That's what I'm talking. Juror, give me your number. Like, try me some numbers. Bill, 22, Mr. Bennett. Lay it on me, Mr. Bennett.
5 years, the out of your home, once you leave your home, is your vehicle considered possession?
My understanding is that it's limited to your residence. And I don't profess to be an expert at the law. Mr. Wilkerson may have a different take on it. And the judge certainly will correct me if I get wrong. But my reading of chapter 46.04 is that after 5 years, it's limited to your residence, your place of residence. My take on the law, my understanding of the law. Anybody else before I move on? All right, way in the back there, Mr. Davis.
You have to remember that that's for the rest of the life.
Oh, Mr. Davis, let me get your number on the record. 51. Yes, go right ahead.
you would never be able to possess a gun though, the rest of your life.
That's current state of the law. That's my understanding of the
No
law.
hunting rifles, no nothing.
It's my understanding of the law, Mr. Davis. I mean, if you think about it, again, we talked about all the ways that the legislature regulates our life. I mean, there are other penalties that go along with being a convicted felon. For instance, you can't vote. For instance, you can't serve on a jury. You can't be sitting where you're sitting if you're a convicted felon. You can't hold public office as a convicted felon. There are other consequences, real world heavyweight consequences that come along with being a convicted felon. So, I'll start another hand back there in the back. Mr. Cabanillas, first injury law, is that what you practice? Yes, please.
Are you able to tell us what is it that he's been charged with? Just
Being an unlawful, being in possession of a firearm as an unlawful person. In other words, let me read it straight from me. Unlawful possession of a firearm. And in this case, what makes it unlawful is having been previously convicted of a felony.
and he served his time for that previous conviction of theft. He did this. He served his punishment. Or are we going to take his rights away?
That's the law.
Yeah, I that is the law.
I heard somebody disagreeing with me. Hold on, let me,
I think that's done.
okay, thank you, Mr. Cabanillas. See, no trapdoor. No take. You're sitting there. Look at it. You're still there. Somebody else is nodding. I heard anything over here.
Yes, what comment is that,
Give me your journal, please.
what is that?
Mr. Oliver, go right ahead, sir.
It's okay, not okay to have a weapon, but it's the decisions you make. So if you, before the felon, would have gotten a permit to carry a weapon, any choice, where is the fine line right there, the decision making?
I don't know that having a permit or not having a permit is of any consequence in this instance, because the law does not carve out or make a defense or an exception to the application of this law. If you have a permit or if you don't have a permit, it's not an issue. It's not an issue. All right, anybody else before I move on to my next topic in my outline here? One thing that I just realized, I always look for trends in my jury. Sometimes we have an inordinate amount of nursing, but we have an inordinate amount of educators. On this particular jury, we have 3 people who were born in or grew up in California. Juror number 30 is Vicky Beaumont. Yes. California. Juror number 40, Baraza, grew up in California, right? And juror number 52, Figueroa. Yes, California. I've never seen 3 people from California. Again, I'm always just looking for stuff like that. I remember our argument. I'm going to get back on task. All right, so that offense is punishable, as the judge mentioned, from anywhere from 2 years in prison up to 10 years in prison. That is the punishment range. And as a juror, you are asked to consider the entire range, okay? I would imagine that juror number 18, Mr. Richard, you could probably envision a situation where the appropriate punishment may be on the lower end of the punishment range, right? Or you can also envision a situation where the appropriate punishment may be on the higher end of the range. For instance, what about if they had prior criminal history?
Would be on the high end. As a person who carries a pistol all the time.
Yeah.
I don't have one with me right now. Just
That's
believe me, I believe in the protection.
Okay.
I travel a lot. It's in the mood with me when I go.
Yes.
I'm skeptical between the mayonnaise and the mustard and served my time in the army. And
Thanks for your service, by the way. Appreciate that. So is there anything else or anybody want to add about that punishment range? Each case, as the judge mentioned, is different. Each defendant's situation is different. I just want to make sure that you, as jurors or as a potential juror, can consider the entire punishment range. Is there anybody here, and this is kind of an important question, so I'm going to go row by row. Is there anybody on the first row who could not consider as little as 2 years in prison or as much as 10 years in prison if I was to defend my case? Please raise your hand. For the record, I've seen no hands being raised, but you did make a face there, Miss Stevenson, juror number 9. I'm watching. It's like an auction. If you scratch your nose, I'm all over. What's that about? You don't like that punishment?
Well, no, it's not that something that we said
It's not.
was,
Well, let's not keep it about. Let's not make it personal. Just tell me what you're feeling. Your thoughts
it
on.
depends on, the range is fine, but if like repeated for the same crime.
Okay.
That's what.
Fair enough. Thank you, Ms. Hicks. Thanks for sharing that. Next row, is anybody on the second row who could not consider the entire range of punishment as little as 2, as much as 10? Raise your hand. All right, no hands are being raised. Third row, same question. Raise your hand if you can't consider that entire punishment range. I'm not trying to pin you down. I'm not trying to get you to commit to any amount at this point. I'm just asking that whether or not you can consider it in for however long. You can consider it for a minute, 2 minutes. All right, I thought about 2 years. I'm done. Now I'm thinking about something else. Third row, anybody who can't do that. And back on the back row, is there anybody on the back row who cannot consider that full range punishment? No hands are raised on the third or the fourth row. Beyond a reasonable doubt, I've used that term, the judges use that term. She's told you there is no definition of what beyond a reasonable doubt is. It's whatever that level of proof within you is attained for you to reach that point, at least in my opinion, where you say to yourself, there is no other doubt that's reasonable in this case based on the evidence in this case. The way I like to look at it is, if you know it, if you feel it in your head, in your heart, and in your gut, then I would submit to you that that's enough to get to beyond a reasonable doubt. Mr. Hawkins, juror number 7, what do you think about the notion of beyond a reasonable doubt? What do you think about that? Let me give you something to think about. Let me get something, because I don't like putting people on the spot. From time to time, I do a PowerPoint when I'm feeling techie, and then on that PowerPoint, there's like a puzzle, and it's got like some pieces missing. If you remember those old school jigsaw puzzles, and if you got, let's say, 95% of those pieces in that puzzle, you could probably make out what that puzzle is. When you agree. Now, you would probably want the other 5% of those pieces to make the full picture, but would you agree with me that maybe with 95% of the pieces, you would know in your head, in your heart, in your gut, what that puzzle represents? That's how I like to look beyond a reasonable. Okay. Again, Mr. Wilkerson may have a spin on it, but that's how I like to look at it. I will tell you what beyond a reasonable doubt is not. Juror number 2, Mr. Doesn't pronounce it wrong. John, yes. I'll tell you what it's not. Yeah, it is not 100% proof. Okay. The legislature does not require me to convince you or bring you 100% proof that a defendant is guilty of an offense. They just don't do it. I mean, because if you think about it, who have I not called on there? If you think about it, juror number 26 or so. Yeah. If you think about it, what's the only way for you to know something with 100% certainty? Okay. Well, help him out. What's the only way to know? Yeah, I've seen it. And so the legislature recognizes that, because if you saw it, then you'd be on my witness list. You wouldn't be a potential juror. So the legislature doesn't require me to bring you 3 nuns, the DNA like you see on these TV shows, satellite photos, and all that other business. Just so long as, again, you're gonna get tired of me saying this, I can bring you evidence to the extent that in your head, in your heart, and in your gut, you are convinced. And I don't like that jigsaw puzzle example that I've used. Mr. Blaylock, juror 39.
Yes, sir.
You follow me on that?
Yes, sir.
Anything about that? Would you require 100%? No. Sales with I-Corp. Where's I-Corp do?
This machine shop, job shop.
Okay. So again, this is another one of those important questions. I'm going to go row by row. Anybody on the first row who would require me to prove my case with 100% certainty? 100% proof. Raise your hand. No hands have been raised in the first row, second row. Anybody who would require 100% certainty? 100% proof. No hands have been raised. Third row, same question. Raise your hands if you need 100% proof. No hands. And finally, back, somebody, anybody. Is there someone who would require 100% proof? Can we get there with just what? Head, heart, you gut, and you feel it, then there you go. Now, I'm not saying that there won't be any evidence, okay? I wouldn't be here bringing this case if there wouldn't be any evidence. And I want to talk, Mr. Rogers, juror 15, about evidence and the types of evidence. Is testimony evidence? Yes, testimony is evidence, particularly if you believe, especially if you believe. Juror number 5, Ms. Simeon, let me ask you this one. You're leaving the parking lot today after this jury selection, and it's just you, it's late, it's after 5 o'clock. Somebody walks up to you, and points the gun at you, takes your purse. There's no video of it. There's no other witnesses. You go to the police and you say, look, I got a good description of this guy. He took my purse at gunpoint. Should the police not take your report just because there are no other witnesses or surveillance video? They should take your report, right? Should the district attorney's office not prosecute the case because there are no surveillance video, there is no DNA, there's not the 3 nuns who saw this thing happen? Should my office not prosecute the case? Should prosecute the case. Should you not get an opportunity to take that stand and testify to a jury of your peers that in the city catch the guy sitting in the courtroom? Should they not hear from you that, hey, that's the guy that stole my purse at gunpoint? No.
They should take my statement.
That's my point. You can believe Ms. Simeon or you cannot believe Ms. Simeon, but her testimony is evidence if you find it beyond a reasonable doubt. If you believe her beyond a reasonable doubt. People have been proving these cases for many, many years. So there was a video and all this other technical stuff based on witness testimony alone, just so long as you believe that witness testimony. Jury 35, Ms. Ryer. Mr. Ryer? Where's your 35? Mr. Ryer. I was looking at Ms. Dale on 34. I'm gonna come back to you. But could you render a verdict if you believed that witness, who is the only witness in the case, beyond a reasonable doubt? Or would you need more proof than just witness testimony? And make no mistake, I'm not trying to trick you. It's not a trick question. I'm saying that you have to believe, beyond a reasonable doubt, But if you don't believe beyond a reasonable doubt, then I'm not asking you to convict, or I wouldn't ask you to convict for number 13 years prior. Okay? So another form of evidence, circumstantial evidence. Circumstantial evidence, and I've heard this example used, and it's been used many, many years. Jar of cookies in the kitchen, you got a toddler, you say, don't eat the cookies because it's dinner time, it's close, and you leave the kitchen, you come back, cookies are missing, the toddler is in another room, but the toddler has crumbs, cookie crumbs on his face, hands. What do you suspect has happened, Miss Adrenaline, Miss Skinner? What do you think is happening? Yeah, the cookies. It's circumstantial evidence because why? You can see him eat it. You don't have video of him eating it, but there's proof in the form of circumstantial evidence. The crumbs, okay, and probably the fact that you know your kid. So testimony, circumstantial evidence. This is all evidence. You don't necessarily have to have those things that these TV shows convince you that you need to have, like DNA and cell photos and that kind of. Is there anybody here who would require those types of evidence? Let me ask it this way. Is there anybody here who couldn't base their verdict on circumstantial evidence and or witness testimony if you believe either one of them or both of them beyond a reasonable doubt? All right, no hands been raised. All right, I'm just about to at the end of my outline. 5 minutes, Judge. Thank you, Judge. The defendant's not required to testify, okay? I don't want you to hold that against him. I usually spend a little bit more time on this topic, but I'm running out of time. So for the sake of time, I'm not going to go our way again. I'm just going to ask, don't hold it against him. It's not his job to disprove his guilt. It's my job to prove his guilt. So if he doesn't take a stand, doesn't testify, don't hold that against him. Another thing, by virtue or by the nature of this offense, the way it's charged is he would have to have been a felon prior to possessing the firearm if you believe beyond a reasonable doubt. I don't want you to hold the fact that he is a felon or was a felon against him, okay? Don't say that he must be guilty of this because he was already a convicted felon, okay? Again, I'll normally spend more time on this, but for the sake of time, I'm not going to drill down on it. But you follow me. Is there anybody here who would say, well, he's already a convicted felon. He must have done this new crime of possessing or unlawfully possessing a firearm. Is there anybody here who would do that? Raise your hand. Record, no hands being raised. I think that's about it. I got just a few more questions.
And we have time if you need a few minutes.
Okay, so I'm wrapping it up. Is there anybody here, and if this is too personal of a question, we can ask the judge to allow you to approach out of the hearing of the other jurors and maybe discuss it at the bench. But is there anybody here who has a friend, a family member, someone close to you who is a convicted felon and you may think that they have been treated unfairly because of their status as a felon? Again, if this is something that's too personal, then you just raise your hand and let me know that you got that issue. Okay, maybe talk to the judge. But let's do this, Mr. Richard. Let me go over our ones. This is one of those important ones. Is anybody on this first row on this side who knows somebody close to a family member who they haven't been convicted felon, but you feel like they've been treated unfairly, maybe in employment or maybe not employment opportunities or denied whatever these rights are that we talked about, the right to vote, the right to serve on the jury, hold office. Anybody here on this first row of this side? Hold on a second, Miss. Make it look. All right. Okay. Juror number 5, Miss Simeon. Yes, ma'am.
I've had a cousin, actually 2 cousins that were convicted felons, but I don't say that they were, treated unfair, because I wasn't in courtroom. But I have had a couple cousins that I was raised with that was convicted felons, and I've had one of them that actually was murdered.
Wow. And here's what I'm really getting at is whether or not that experience, the experience with your cousins, would somehow make you not be fair or impartial in this case. In other words, is that something that would color your ability as a juror to just render a verdict based solely on the evidence in this case? Anybody else? First row of this side, juror number 4? 11. How am I that far off? 11, Ms. Ramirez. Yes, ma'am.
I also I've known someone that was a convicted felon and has had to serve a long term for being one. So I don't feel like it would in any way affect my judgment though on anybody else's situation. Yeah.
Okay, good. Thanks for your honesty. I appreciate that. And you already answered the second part of my question. Would that affect your ability to be fair and employment? Anybody else on this side, first row? Second row, Mr. Richard, you had your hand up, juror number 18? Yes, sir.
Yeah, I got a cousin convicted felon, had a brother-in-law who was passed away, who was convicted both. But one of them, I felt like he was wrong to do by being convicted.
And that's a whole separate.
Yeah, that's a separate issue.
Yeah, whether or not the conviction was justified or not, what I'm getting at is the consequences or the penalties associated with it afterwards. Do you have any strong feelings about that as it relates to those folks?
I guess not. He's a hustler piece about it.
Oh, all right, me too. Anybody else on the second row? Friend, family member close, someone close to you, you think they've been unfairly saddled with the felony conviction or the penalties associated with it? Anybody on the third row? Friend, family member, somebody close to you, and it will be to the extent where it's kind of in the back of your mind during this trial. I see a hand, you get a number,
Not sure what number is. I've been Durant.
43, Mr. Durant. Yes.
My father, was felon.
Yes.
I feel as he has been, kind of had a hard time getting a job after that. I feel like kind of might have been a little bit.
We may want to visit with you a little bit. We may want to visit with you at the bench here a little later on. I appreciate your honesty, Mr. Durant. Anybody else on that third row? Anybody on that last row? Friend, family member, close, someone close to you. I'm fairly saddled. You to the extent that will affect your ability to be fair and impartial. Juror number 60, Miss. Help me with the pronunciation of your name. Just say. I just want to call you. It was way back in the back. And you got your stuck in the corner. I mean, I don't know what you did. I just felt failed to call on you. All right. So, all right. With that being said, does anybody know Detective Lance Carmouche with the Beaumont Police Department? I know you probably do, Sergeant. Is it Turner Kelly? You work for the Sheriff's Department as well. Right? I can understand why you guys how you know it. Is he old? I don't know how to answer that.
What'd she say?
Is he old or young? He's not. It's not what I would consider to be young.
I don't think he's not old though. Carmouche is young, huh?
If you think you know him, we'll bring you up to the picture. Okay. Okay. What about a Daryl Wayne Cooper Sr.? Does that name something maybe? All right. And what about a Imran Kale? He's a local business owner. He also goes by Imran Yance. You might know. All right. Well, I tried to stay as close to 30 minutes as I think I could, ladies and gentlemen. I do believe that you gave me your honest attention and answers during this presentation. And for that, I thank you and I appreciate it. Before I sit down, is there any questions that you think that you can think of that I should have asked that I didn't ask as it relates to the issues in this particular case? All right. I look forward to presenting my case to the 12 of you who are selected. Thanks.
Thank you, Mr. Coleman. Mr. Wilkerson, I think before you get started, ladies and gentlemen, what I'd like to go ahead and do, it never fails. If I get started with the next attorney, somebody's going to need to take a break. And so I'd rather go ahead and take a quick break. That way, Mr. Wilkerson can get straight through his voir dire. Please look at where you're sitting, kind of pay attention to that so that when the bailiffs bring you back in, you can get seated quickly. There are bathrooms at the end of the building this way on the first, second, and third floor. So you can kind of disperse about. And there's also some kind of in between the two buildings. If you go down that way on the second floor, this floor. So it's 10 till 3. I'd like to maybe just make this about 10 or 15 minutes at the most and try to get started at 5 after 3. Okay. Please don't talk about anything that has to do with the case, the people involved in the case. Don't go look up anything. Just take a quick break and come right back. Okay. All right. You're all excused. Okay. So if there's any that you guys already want to discuss, Sergeant Bowman, I would think obviously has the information about transportation and things like that. So I would think that he would have the knowledge that the defendant is in custody, which would be a kind of a built-in problem. Do you guys agree?
I would agree.
And so we can let Sergeant Bowman know. Are y'all fine with him going ahead and being released?
Yes.
Okay, so we'll release Sergeant Bowman. He's number 32 by agreement. And Deputy Williams, you can let him know when they come back. Sharon?
Yes, ma'am.
The only other one, let's go off the record for a minute. So if there is an agreement on number 22, number Bennett.
States in agreement.
Defense is in agreement.
All right, so you can go ahead and let Mr. Bennett know also that he is.
Judge, and I will say this for the record. It also appears that he has a 1982, I know it's old, but death conviction as well.
Okay.
I was going to ask that he be brought up.
Okay, well, we'll just let him go then, unless you want to bring him and visit with him.
So the only other one, you told somebody that you wanted to visit with them privately.
Yeah, there's a couple more, and those are fine. I'll let y'all keep going. I just didn't want them sitting here. Sergeant Bowman and Mr. Bennett don't need to be sitting here if we know we're going to let them go. You can let those two go. All right, let's take a quick.
Good afternoon. So this is the first opportunity I'm gonna have to talk to y'all. And probably the only but definitely the only opportunity I'm gonna have to talk to most of them. This is the process, as you've been advised, whereby we go through and we try and get to know a little bit about jurors. So let me first echo the sentiments of the court for being here. When the state's attorney said justice for the defendant, justice is a process. It is not an ultimate outcome, right? And that process of justice cannot be done without people such as yourselves showing up, being here, so that we can pick a jury, so that a person can have their day in court, right? Force the state to prove their case, confront witnesses against them. And so, as you know, as you were told, we've had problems lately, sometimes filling all these chairs, which I don't anticipate being a problem here today at all. But sometimes with certain kinds of cases, it can make having a jury difficult because of things that trigger people, right? So thank you for being here. You were asked about whether you or anyone close to you has ever been convicted of felony. Obviously, you haven't, or you wouldn't be sitting here. Anybody in here ever been accused or investigated for the commission of a criminal offense? First row.
Hold on, Mr. Wilkerson. I think we might have been missing one. You think that's good? You got them?
Yes, ma'am.
Okay. Yeah, you can pull that up however you want to. Go ahead.
All right, I'll tell you. Couple things about me real quick, switching subjects. So it's getting hotter outside, even in the wintertime. If I walk from my car to the door of this courthouse, especially pulling or carrying my bags, I break out in sweat. And it takes 20-30 minutes for me to stop. So if you see me and I'm dripping wet, it's not abnormal. So just ignore. And I also have COPD. So if I'm talking to you and I have to stop for a moment, catch my breath, that also is not abnormal. So just bear with me if that happens. All right. So back to what I was asking. Before we stop briefly, I had asked, have any of you been accused of committing a criminal offense or investigated in conjunction with a criminal offense? Going down the first row, anybody ever been accused of committing a crime other than trafficking? Yes, ma'am. What's your number again? You are Miss Stevenson?
Yeah.
Yep, okay, so you get your number 9. What was it you who was accused of committing an offense?
No, it was me and my husband.
You and your husband? What was that investigation?
Oh, it was like unlawful neglect of a child, weapon, something like that.
Neglect, child neglect, basically?
Everything, leaving the weapon in the house with the child, not really locking the face.
Was that a criminal investigation or a family case, like just CPS
She
investigation?
dropped down the path.
Okay. So did y'all go through proceedings in family court about that?
I didn't even have to go to family court.
Didn't even have to go? But best outcome. Best outcome. I was gonna take on you later about burdens of proof if you had been through family courts. Thank you for being willing to share that, though. By the way, just as you've been told before, if a question is too personal, you don't want to share it in front of everybody else, that's fine. Just let us know so we can talk to you individually after the brief kind of is sent out. So down toward the end of the first row, anybody accused of or investigated for committing an offense? No. Second row, anybody?
I'm thinking I might have been, but I'm not really quite sure. It turns out that the neighbor that lived like 3 doors down, she was selling more than vacuum cleaners, and somebody asked her. And they took us down to the police station, and I gave a statement, and then 3 months later they brought me in, and I had to make another statement, and they told me that my statements didn't match. And my wife at the time said that he can't remember what he had for breakfast, so they.
I'm right there with you. I
don't know if that was really an investigation or whatnot. But obviously,
I appreciate it. You were already married? Because you said your wife said that. Yeah. Okay. All right. Anybody else on the second row investigated or accused of committing a criminal offense? Going once, going twice. Anybody on the third row investigated or accused of committing a criminal offense? Third row, yes, ma'am. Miss Blow. No. I'm sorry. Barraza. What were you accused of?
It was a At first it was a felony, but they dropped it down to misdemeanor.
Okay. Was it prosecuted?
Um,
Did you have to go to court?
Yes,
Did you do some type of probation on it or, okay. When was that?
over a decade ago.
Decade ago? Do you recall, did you do something called deferred adjudication? Or do you not remember? Decade's a long time.
Yeah,
so-
well, I got probation for it, but
Yeah. What was the underlying allegation?
still,
Thank you for being willing to share that. All right, so anybody else on the third row? Anybody else on the third row? And last right, from left to right, or else right to left. Anybody accused of a crime or investigated in association with a criminal offense? Yes, ma'am, Ms. Green? Is it? No, Ms. Smith, correct? What was your situation?
Talking matter.
Having been the victim or the aggressor? Alleged aggressor. What happened with that?
Found not guilty of that case.
Okay. How long ago was that? Anything about that might affect your ability to be a fair and impartial juror? No. Same question to you, Ms. Barraza. Anything about your experience might affect your ability to be fair and impartial juror? No. And I think it was Miss Stevenson. Anything about your prior experience affect your ability to be fair and impartial juror? Something else about y'all. There are, I think, 15 of you who either are in law enforcement or have family members of law enforcement. And so rather than ask each of you who have that characteristic and picking on all of you individually, I'm going to ask just kind of generically, is there on the first row, for those of you who have either been in law enforcement, whether correctional officer or patrol or other investigators for a federal or state agency, or have a family member who is, anything about that relationship that might impact your service as a juror? Could be good or bad. Is that going to create anything about that relationship, going to create any kind of bias toward an officer's testimony or detective's testimony? Or can everybody agree on the first row that a witness steps in, no matter who they are, with the same level of credibility, and as they testify, their credibility is the same? All right. Second row. For those of you, I think there's 4 or 5 of you on the second row. For those of you on the second row who have that characteristic, that either yourself have been involved in law enforcement or have a family member who is involved in law enforcement, anything about those experiences or relationships that might affect your ability to be a fair and impartial juror? No, sir. And no. Third row, same question. For those of you who have been in law enforcement or have served in law enforcement of some type themselves, anybody have any problems being fair and impartial based on that? And then let's see, 50 and 51. It's a first for me too, husband and wife being sitting next to each other. Both of y'all have a son who's in law enforcement, correct? Right. No. Anything about that? Anything about that might interfere with your ability to be fair and impartial? No. Got it. All right. Thank you. All right. You heard an often used allegory mentioned by the state's attorney during his voir dire presentation, and it was that of a jigsaw puzzle. And so, because of the nature of the case and because of the evidence being presented, I didn't really feel it necessary to do a big slideshow for y'all. So instead, I'm going to ask you to just envision something in your mind, right? And I want you to envision a jigsaw puzzle that is a picture of a firearm. But imagine at the end of that firearm, that piece, that one piece from the puzzle is the only piece missing, right? And then you put that piece down and all of a sudden it's got an orange tip, despite otherwise looking completely realistic. Does that one puzzle piece change the nature of the object that you see? On one hand, you are looking at a photo of a realistic looking firearm, right? But on the other, as soon as that piece is added, you're dealing with an airsoft gun or maybe a paintball gun. So one puzzle piece, ladies and gentlemen, and that's just an example designed to show you and tell you, just one small piece of puzzle can change everything. And you're not always gonna know. Well, obviously, if those pieces are missing, there are reasons that they're missing. So just keep an open mind. We aren't, we can't define for you beyond reasonable doubt, but what I can tell you is that it is the highest burden of proof. I was gonna pick on you again, but you didn't even go to family court in your situation, so anybody want to tell me what level or burden of proof they think the state has to reach to terminate your relationship with your kid for some sort of, well, all they really have to find is that it's in that kid's best interest. Anybody want to take a stab at it? Burden of
I
proof?
have a question on that.
Yes, ma'am.
Airsoft gun, if
Huh?
that is gonna be up for discussion, I would need proof that it's not an airsoft gun.
So, and just for clarification, the examples that we use during voir dire aren't necessarily related to the case, but I will tell you that a firearm is legally defined, and a firearm requires that it be capable of projecting a bullet by combustion, right? And so,
The definition will be in the charge. Like he's saying, yeah.
but you would want proof that whatever is seen is actually a firearm as defined by the law.
Correct.
Anybody else feel the same way? Yes, sir. Number 4, you feel the same way. You're number 2. Yes, ma'am. I'm sorry. I already talked to 40. Yes, ma'am. Somebody back here on the 3rd row, raise their hand. What's your name, ma'am? 36. You feel the same way. And then somebody on the very last row. Yes, sir. What's your name, sir?
James Garner, 57.
Mr. Garner. Thank you.
Yeah, I'm aware that there are some, that it's important to define the firearm, that it's actually a firearm.
All right. Thank you. Thank you for those comments. And
Agree with that as well.
what's your number, ma'am?
11.
11. Thank you. Y'all can tell me faster than I can look it up. I'm sorry. No matter how plainly I even type the names in, by the end of the day, this is what y'all's charts look like. And as you can see, my handwriting is not the prettiest in the world. So it gets a little crazy when I'm trying to who's who and counting chairs real quick to try and figure it out. So I do apologize, but thank you. And thank you for volunteering that. Circling back on getting back to burdens of proof. And again, the state is required to prove every element of the offense, right? That a firearm is indeed a firearm. It's one of those elements that the state's required to prove. And so, they have to prove that beyond a reasonable doubt. And the reason I was asking about terminating a parent and a child's relationship is because that standard for all of those of you who have never been accused of a crime or have been investigated in relation to a criminal offense, a vast number of you, the majority by far, have children, whether those children are still young or are 30, 40, 50 years old now. And so I ask you, when you're talking about what the state has to prove and when holding them to the burden, that highest level of what they have to prove, ask yourself, if the state of Texas wanted to sever my relationship with my child, what level of proofs would I want them to have to be held to? Right? That's clear and convincing evidence. That's not even beyond a reasonable doubt, right? It's a step down. So when you're thinking about burdens of proof, when you're thinking about those things, if you've never been accused of a crime or you don't have a family member who's been convicted of an offense, then oftentimes these terms, they are very abstract, right? And while we see them on TV shows, we don't go around talking about, I believe beyond a reasonable doubt my son stole the cookie out of the cookie jar. We just don't talk like that, right? And so when you come in to be selected, when you come in and you serve jury duties and you're talking about the case and talking about the evidence and talking about these legal ideas, these legal requirements, right? Try the best way to understand them is to be able to somehow relate them to your own personal experience. And I would venture to guess that none of you have had your relationship with your children terminated by the state either. But those of you who do have kids, I imagine have some kind of feeling about if they wanted to do that, what level or what evidence would you want them to be required to present in order to do it? Obviously, people's relationships with their children are sacred, right? And so that's why I often point to that example. We talked about a missing puzzle piece. Anybody ever looked at those? Y'all know what fractal art is? Anybody know what fractals are? I see a couple heads nodding. Let me go back to the 3rd row, ma'am, sir.
5.
Mr. Reinhardt, 35, you've seen Frack Alert before?
Yes.
And so can you, well, and Ms. Dale, you've seen it before as well, correct? Can one of you explain for everybody what Frack Alert is?
Well, it's taking apart items and reflective and it differently goes into a direction. Whereas well, basically it's, it keeps on going and going and going. It takes parts of it, look at that plot, it keeps on going, just repeats.
And those art pieces that are often created by use of mathematical equations, they also, for some people, show 3D images, right? Not everybody can see it though. You have to really relax your eyes and kind of stare off into the distance. Anybody else remember doing that? Maybe staring at a poster, see a couple heads nodding, a couple hands coming up, right? So by some token, anybody ever look at those drawings or photographs that say, what do you see? Right? Anybody get it? Especially if you're on social media, you've probably seen those before, right? Where somebody's like, hey, what do you see in this picture? And so when I put video presentation up, I show you an image like that where people can see different things. And the sole purpose of that is to remind everyone that two people can look at the exact same image from two entirely different perspectives, right? And that's why a verdict requires all of you rather than just a few, because you all come from different perspectives, right? You all see things based on your own experiences. And so I just want everybody, if you are selected to serve on this jury, to remember as you go into this case that just because one person or one witness tells you something is the way they perceive it, it does not necessarily mean that's how you should perceive it. Oftentimes, all over our life, talk about media, for instance. Most media today is commentary rather than straight news, right? Whatever side of the aisle you're on, whatever channels you watch, it is not as much factual as it is telling you how they feel about it, kind of what you should feel about it, right? When a witness testifies, they're testifying as to their observation of facts. Just because the way they perceive the fact is one way, doesn't mean that there aren't other possibilities. And I just want each of you to be able to keep that in mind going into this process. All right. So, and then circling back, I had some questions for some of you that y'all fill out these questionnaires, right? When you are contacted and asked to serve on jury duty, especially with the iJur system, you fill them out. And by the way, Mr. Bishop, pick on you for just a minute. Thank you for writing. You wrote probably more than I've ever seen in a juror questionnaire. But no, I mean, I kid about it, right? And some of you giggle, but these little questionnaires and these 30 minutes that we get with y'all don't give us an opportunity to really get to know you and what your life consists of on a day-to-day basis. And whether you recognize it or not, those patterns in your life on a day-to-day basis, what you've seen and what you've experienced, all impact how you form your decisions, how you make your decisions, and what you see, how you see it, right? So in trying to learn a little bit about health, that's why we try and do it in different ways: hobbies, right? Interests, family dynamics. Miss Timmy, your husband's retired. Where did he retire from?
Or Meyer.
I'm sorry?
Meyer. It was he was a truck driver.
Truck driver? Okay. All right. Thank you very much. Mr. Walker, number 25. Mr. Walker. Yep. Thank you. You're a teacher. What grade do you teach?
Right now, middle school.
Middle school. Have you, which district do you teach in?
Beaumont.
Beaumont ISD. Do you have, and I know you're crazy, it seems like every day, but do you have students? Obviously, your students aren't charged with felonies because they are juveniles. But do you have students who get in, I guess, commit unruly acts or maybe get in fights or whatnot, things that if they were adults might result in criminal charges? No. And do you, when you're getting to know those kids, you spend in middle school, you still spend what, a semester, or y'all in trimesters?
It's 9 weeks or a semester.
9 weeks a semester. But you spend 9 weeks with these kids, basically, right?
Now, over here.
Whole year? Okay. And so is it fair to make a determination about a kid during the first week, or have you, let me ask it to you this way. Have you made a determination or started to feel like you understood a child, and then later on, maybe weeks later, maybe months later, learned something new or saw some change that made you rethink those assumptions and beliefs regarding that child?
Not necessarily. The child changes, something happens in their environment.
Children grow, people grow though, correct? So everybody, we're always learning. Everything we interact with becomes part of our life experience, right? No matter how short, how brief, or how meaningful and deep that interaction is. We're all growing and changing every day. Let's see. I think next to Mr. Walker, Mr. Allen, you
Yes, sir.
your spouse. Oh wait, you're not married. Never mind. You skip over. Sorry. Mr. Oliver. Olivier, is it Olivier?
Oliver over here texted Olivier. That.
Gotcha. All right. Both of you and your wife are retired, right? Right. Where'd y'all retire from?
My wife retired from was Time Warner Cable.
Okay.
25 years manager. I retired last pretty job construction with brand Safeway.
Okay.
Prior to that, I was a manager at Walmart, Lowe's, Americo, Simple, Synthetic Rubber Company.
Gotcha.
And Texaco back in the day, 80s.
Brand, is that Brand Corporation?
Safeway Corporation.
Safeway,
Definitely, I drove heavy duty machinery, Fort Mill.
construction. Place. Okay. So you've done a lot of different things from retail to construction and whatnot over the course of your life. Okay. And you said that, I'm sorry, you said that your wife was a manager at Time Warner.
Yeah, cable company back then, Spectrum.
Was she a customer service or lineman or customer service? All right. Thank you. Let's see. Juror number 33. What, well, first of all, you have a brother in law enforcement, right? Are y'all close?
Bolton?
Yes, Moten, 33.
Yeah. I have a brother.
You have a brother in law enforcement. Are y'all close?
Yes.
Do y'all talk about him being out on I can't remember what type of officer you said that he was.
He was a jailer and a transport.
Jailer. So y'all talk about
He talks a lot.
it talks a lot. Does it talk about the people that he deals with in the facility?
Yes.
And but in terms of hearing all of that talk, nothing about that's going to change how you perceive witnesses in this case, one way or another.
No, I just listen to what he got to say.
Let him talk. Is your wife is retired, correct?
Respiratory therapist.
Respiratory therapy. Okay, thank you.
Mr. Wilkerson, you have about 5 minutes.
Okay, thank you on this one. Let's see. I know married couple in the back are landlords. Miss Figueroa, you are also a teacher. What grade?
Fifth grade.
I'm sorry.
Pre-K through 5th grade.
Okay, you got them real young, huh? What district?
Port Arthur.
Port Arthur. Well, all of you teachers, thanks for everything you do. Because things really are getting crazy. Jurors number 38 and 41. I want to pick on y'all for just a second. I'm running out of time. Both of you, though, and a couple others, I believe, but both of you. Let me see, Mr. Billy, is that correct? Miss Billy. Okay, thank you, and Mr. Ward. Correct. Okay. Both of y'all had served on criminal jury trials that went to verdict before. Correct. What trial? What, Miss Billy? What was your trial?
Well, I've been on 3, but the most recent one was Judge Stevens. With Samantha, the police officer. Can't think of her name.
How long ago? Was
It's
that?
been a year and a year and a half, 2 years ago. What did I say? I'm not sure. I just, without just saying it, she was killed by a drug.
Right.
But I cannot think of Samantha's first name.
I understand. Yes, ma'am. I know what case you're talking about. I don't remember her name.
I remember the names, don't remember his name, but
Yeah.
yes, I served on now.
Okay. And your other two, did they also go to verdict?
Yes.
Were they also felonies or,
One was felony, yes.
all right, were all of your verdicts guilty verdicts?
Yes.
Okay. And then, Mr. Ward, how many criminal trials have you served on? Criminal juries, I'm sorry.
2.
2? How long ago?
Yeah, very yes, your code has been in plus 15 years ago.
Okay.
Now speak for a jury, this court, that's the kind of being with Bob.
Okay, beginning of trial, do you recall who the defendant was?
No,
None. What happened to that trial? Did it go to verdict or?
Whoever's phone that is, can y'all make sure and turn your phone off, please? That's okay.
Was there a plea or something like that that happened, so the defendant changed their plea before trial actually got going? Okay. Both of your jury service, both of your times on jury service for criminal trials went to verdict? Well, I'm sorry, only the first one went to verdict. And was that a guilty verdict? Okay. All right. Y'all, thanks for bearing with me. Thanks for playing along, responding, even if it was head nods. At least I know you're awake and paying attention. Thanks for being here, truly.
Thank you, Mr. Wilkerson. And so, ladies and gentlemen, what I'm going to do now is ask, I've got a list that I've been compiling with the attorneys probably of just a few of you that we need to come back in and visit with about some questions. Is there anyone who, now not because of work, so I have to be careful how I ask this question, because I can't excuse you for work-related reasons. But if something came up from the time that you signed up for jury duty and now medically, if you have some procedure that would make it where you could not be here for the next 3 or 4 days, is there anyone who has any issues like that for just the next few days this week? Yes, sir. And what is your number in the back? And is that something you want to share privately, or do you want to talk about what?
My mom tomorrow.
Your mom has an appointment tomorrow? Is there no one else that can take her to that appointment? What time is that appointment tomorrow? Okay. Anyone else with anything like that? Hold on. I'm sorry? And you are, is it number 12, Mr. Moman?
Yes.
And what time is your appointment?
1 o'clock.
And where is it?
Houston?
In Houston? It's not something that can be changed?
No.
Anyone else? So what I'm going to do, if I can ask if everyone just be real quiet for just a minute, I'm going to have the lawyers come up so we can make sure our lists are the same, and then I'll let you all know who we need to visit with. Mr. Coleman and Mr. All right, let the record reflect state's attorneys present, defendant and defense counsel are present. Anything we need to take up before we bring the jury in?
John, I don't know, would you want my witnesses sworn in front of the jury?
Either
That would be
way.
my preference.
Sure.
Yes, other than that, Judge, nothing for mistake.
Mr. Wilkerson?
Judge, the only thing I would mention is I noticed you sent us a charge last night. I just want to notify the court on notice that we'll be requesting instructions, both of a lesser included and of the voluntariness of the statement.
Well, let's get through the trial before we talk
Yes.
about the charge. And are your witnesses down here and ready?
They should be. As I was coming down, I told my investigator to give them that.
Thank you. All right, you can bring the jury in. And obviously, if either of you anticipate any witnesses that are not here at this point, make sure you send messages or do whatever you need to inform them what the rule is and that they're placed under the rule and that they're specifically instructed not to watch anything on YouTube.
Yes, Judge.
Good afternoon, ladies and gentlemen. I want to thank you very much for your patience this afternoon. I apologize that we're getting started so late. I'm now calling the case of the state of Texas versus Romeo R. Johnson, aka Romeo Randolph Johnson. And is the state ready to proceed?
State's ready, Judge.
Defense ready.
It's ready, Graham.
Ladies and gentlemen, if you'll all please remain seated and raise your right hand. Do you and each of you solemnly swear or affirm that in the case of the state of Texas against the defendant, you will a true verdict render according to the law and the evidence?
Okay.
Thank you. And does the rule has been invoked, and if you have any witnesses, if you'll please have them come in.
Right on with you.
And again, this is 25 DCCR 1626. I'm not sure I said that. How are you? All right, if all of you would please raise your right hand. Do you and each of you solemnly swear or affirm that the testimony you give in this trial will be the truth, the whole truth, and nothing but the truth? Thank you. You can put your hands down. So the rule is invoked, and what that means is that you're not allowed to be in the courtroom for anyone else's testimony. You're instructed not to discuss your testimony with anyone involved in the trial other than the lawyers or the investigators. And you're specifically instructed you cannot watch any of the proceedings on YouTube. All right, y'all can all step back outside the courtroom. Thank you. Mr. Coleman, you may present the indictment. Mr. Johnson, if you'll please stand.
In the name and by the authority of the state of Texas, the grand jurors for the county of Jefferson, state aforesaid, duly organized as such at the July term AD 2025 of the 252nd District Court of Jefferson County in said county and state, upon oath in said court, present that Romeo R. Johnson, aka Romeo Randolph Johnson, hereinafter styled the defendant, on or about the 14th day of September 2024, and anterior to the presentment of this indictment in the county of Jefferson and state of Texas, did then and there, having been convicted. I'm looking at the amended.
I'm so sorry.
There's
Carry on.
one that was amended
Yes, sir. Yes, sir.
on
I'm sorry.
11/4.
Got it. I'm sorry.
I should have pointed that out.
That's okay. I should have it. Thank you. Sorry.
That's okay. I'll start over. In the name and by the authority of the state of Texas, the grand jurors for the county of Jefferson, state aforesaid, duly organized as such that at the July term AD 2025 of the 252nd District Court of Jefferson County in said county and state, upon oath in said court, present that Romeo R. Johnson, aka Romeo Randolph Johnson, hereinafter styled the defendant, on or about the 14th day of September 2024, anterior to the presentment of this indictment in the county of Jefferson and state of Texas, did then and there, having been convicted of the felony offense of evading arrest, detention with previous convictions on April the 13th of 2022 in cause number 20-34416 in the criminal district court of Jefferson County, Texas, intentionally, knowingly, and recklessly possessed a firearm before the 5th anniversary of the defendant's release from confinement following conviction of the felony against the peace and dignity of the state.
And how does the defendant plead? Thank you, sir. You can have a seat. All right. Does Mr. Coleman, do you wish to make an opening statement?
Just briefly, Your Honor. Thank you, Mayor. Please, the court, counsel, ladies and gentlemen of the jury. This case is straightforward, at least in my opinion, but it is nonetheless a serious case. I anticipate that the evidence will show that there was surveillance video from the early morning hours of September the 14th of 2024 in the parking lot of what's known as the Amigos restaurant off of College near Avenue D. The surveillance video, while admittedly not the best quality video, will show this defendant, Romeo Johnson, get into an altercation with another individual over what the defendant calls merchandise. During this altercation, this defendant brandished a firearm. He would use that firearm, in my opinion, to intimidate the other individual in that video. And he would hand that firearm off to another individual before leaving that parking lot. The evidence in this case will also show that in a subsequent court proceeding, this defendant took the stand, swore under oath, so too, and during his sworn testimony, he testified that at that same day, at that exact moment depicted in that video, that he in fact did brandish a firearm, a gun, is what he referred to as. The state will ask that you consider the video, you consider the defendant's sworn testimony, and you consider that in the light of your common sense. During the sworn testimony, at no point, the term gun was mentioned during his questioning no less than 6 times. During his testimony, at no time did the defendant say it was a pellet gun, a BB gun, a fake gun, a replica gun. He was very clear that the gun that he had, he gave back to a certain individual. That was him on that video with a gun. So I'm asking you that based on the video, based on the defendant's sworn testimony, and based on your common sense, like we talked about during jury selection, that you find this defendant guilty of this offense. One last thing I want to add is the firearm wasn't recovered. We do not have a firearm, we will not be bringing you that firearm. But I will say this, like we talked about during jury selection, if you got enough of those puzzle pieces there, and you believe it beyond a reasonable doubt, then that's enough. That is enough for you to find this defendant guilty beyond a reasonable doubt. If you believe his sworn testimony from that witness stand, if you believe your own eyes and your common sense that at 2 o'clock in the morning in an argument over quote unquote merchandise, that this defendant would be brandishing a firearm, that is enough. And that's what I'm going to ask you to base your verdict on. Your verdict of guilty, find this defendant guilty of the offense of unlawfully possessing a firearm after having been convicted of a felony.
Thank you, Mr. Coleman. Mr. Wilkerson, do you wish to make an opening statement?
Yes, Your Honor, just briefly. Afternoon, ladies and gentlemen, and we thank you again for being here, for doing your civic duty that allows us to engage in this process of justice. I agree in part with the state's attorney. I do not agree that this case is very straightforward. The evidence that you're going to have before you is a video that makes nothing clear. You have been told about a statement that this defendant made under oath. You will be asked to consider a very, very brief portion of that statement. You'll know nothing about what was going on in the circumstances under which the defendant made that statement. You will notice the state has admitted to you that there will be no term firearm discussed. You'll see in the statement that the answers given by the defendant are very tightly choreographed and controlled by the state's attorney himself during questioning, as he over and over tells the defendant to answer yes or no questions. So at the end of all of that, you'll also hear from a detective who had this video for some other investigative purpose. What you'll learn is that a offense report was completed on October 15th, October 14th of 2025. You'll learn from that same detective that a complaint was then submitted on October 15th, 2025 for statements that he was not present for and did not hear. And at the end of all of it, you'll be asked to consider several things, right? Did the state prove beyond a reasonable doubt that this defendant possessed a firearm? And with regard to the statement that the prosecution keeps referencing, was that statement even given voluntarily? Most of you look forward to y'all hearing it, please.
Thank you, Mr. Wilkerson. Mr. Coleman, you may call your first witness.
This time the state called Amron Kale.
Amron Kale.
And Mr. Kale, do you own certain property that is associated with the Amigos Food Mart here in Beaumont, Texas?
Yes, sir.
And where is that property located, sir?
Address is 1695 College Street, Beaumont, Texas, 77701.
Is that near Avenue D?
Yes, sir.
And Beaumont, of course, is in Jefferson County, Texas, correct?
Yes, sir.
Back in September of 2024, September 14th to be more specific, was that particular property outfitted with surveillance equipment?
Yes, sir.
And that surveillance equipment was capable of making a recording?
Yes, sir.
As far as you know, capable of making an accurate recording, correct?
No, sir.
Well, then listen to my question. As far as you know, was it capable of making an accurate recording?
Accurate? Yes, sir.
Okay. And you, as the owner of that property, you certainly had access to the property and also access to that recording equipment if you chose to, correct?
Yes, sir.
And do you have any reason to believe that back on September the 14th of 2024 that recording equipment was not operating properly?
No, sir.
In fact, have you viewed certain video from that day, from the early morning hours of that day? Have you viewed video?
Yes, sir.
And May I approach the witness, Judge?
You may.
Yeah, I'm going to hand you what I am marking as State's Exhibit number 1. Before we talk about State's Exhibit number 1, I'm going to ask you whether or not you recognize this.
Yes, sir.
How do you recognize it?
I'm the one who wrote it. Yes, sir.
You wrote your initials here
And the date.
in today's date?
Yes, sir.
What does that signify?
That it belonged to me.
All right, that you reviewed it prior to your testimony here today?
Yes.
And is this video from September the 14th of 2024 at the location there at the Amigos Food Mart?
Yes, sir.
And you know this to be video based on what?
The resemblance outside this my location.
No,
Yes.
you know that what's outside of that location.
Yes, sir.
And you recognize it from looking at the video.
Correct.
Any reason to believe that the video contained on this USB drive has been in any way altered or manipulated?
No, sir.
Judge, at this time, State Office State's Exhibit number 1, it has been previously provided to defense counsel in discovery, tendered to him for his inspection.
No objection, Your Honor.
State's one's admitted.
Now, in addition to the video or videos, different video angles there on State's Exhibit number 1, there have been certain still photos.
Yes, sir.
That were screenshot from the video.
Correct.
Right? And those screenshots, what we have done is save them to another USB drive, and we've also printed them out, correct?
Correct.
May I approach the witness, Judge?
You may.
I am going to show you what I'm going to mark with State's Exhibit number 2 and 3 through 8. Let's start with State's Exhibit number 2, this USB drive. Do you recognize this USB drive? So I'm going to get it out of the package. Do you recognize this USB drive?
Yes, sir.
How do you recognize it?
My initial, my date.
Okay.
Yes.
Today's date?
Correct.
And you meaning signifying that you reviewed it, and the still photos that it contains, are they true and accurate copies of still photos that were screenshot from the video that's contained in State's Exhibit number 1?
Yes, sir.
And we printed out those still shots, and I'll ask you to take a look at State's Exhibits 3 through 8 and let me know if those are true and accurate printed copies of the still photos from State's Exhibit number 2.
Yes, sir.
Your Honor, at this time, State Officer State's Exhibit number 2 through 8. It's been previously provided to Defense Counsel, discovery and tendered to Defense Counsel for his inspection.
One other witness briefly.
Sure.
Mr. Hale, did you take these screenshots?
No, sir.
Did somebody else from a state or government office take these screenshots?
Could be, possibly.
Could be possibly, okay. And these screenshots, are these the size of the images on the recording?
Yes, sir.
Or are these screenshots in some way zoomed in?
Look like it's been zoomed in.
Looks like it's been zoomed in. So you can't say with any, since you didn't take these.
Mr. Wilkerson, come up to the podium.
Since you didn't take these screenshots, and since you didn't zoom in with them, you can't say with any certainty that these screenshots haven't been manipulated, can you?
No, they look 100% genuine to me, sir.
Okay, well, what I'm asking you, based on the fact that you didn't take these, based on the fact that you didn't create zoomed in images, well, do you know how the zoomed in images were created?
No, sir.
But do you know how the extra pixels were generated when the zoomed in photographs were taken?
I mean, it could be easily done through the recording. It's the screenshot that, I have surveillance cameras at my location, and if I want to take a screenshot, but the resolution and the image look identical to the video that I've seen.
The resolution of
Yeah, the resolution, yes.
when you take a screenshot from that video, the pictures come out this size?
Because it's not high quality pictures, the quality cameras, so it's not, you're not gonna get a perfect clear picture.
What I asked is, do the screenshots come out this size?
Objection, Judge. It's been asked and answered. I think it's getting argumentative at this point.
Sustained.
Your Honor, we object to the omission of exhibits 2 through 8.
Your Honor, I believe the proper verdict is today.
Objections overruled. States Exhibit 2 and then 3 through 8 are admitted.
Thank you, Your Honor. I'll pass this witness. Thank you, Mr. Kidd.
Any questions, Mr.
No further questions for this witness, Your Honor.
Any objection to Mr. Kale being excused?
No.
None from the.
Thank you, Mr. Kale.
Thank you.
You may call your next witness.
Your Honor, this time the state of Texas would like to offer an exhibit that is self-authenticating, and that exhibit would be, just get a second, Judge. That would be an excerpt from a prior court proceeding, Your Honor, involving this defendant that I'm marking as State's Exhibit number 9. And it has been, it's a certified copy of a transcript, and it's been previously provided to the defense counsel as part of my notice of intention to introduce this transcript. For the record, I'm tendered to defense counsel for the inspection.
Object both under the rules of optional completeness and the rules at 403, Your Honor.
That's overruled. States 9 is admitted.
Likewise, the state would also offer, for calling my next witness, State's Exhibit number 10, which is a certified judgment that I proffer and represent to the court is the underlying predicate felony read to the jury in the indictment. There is a procedural matter with regard to the introduction of this that I think we need to talk to the court about before I tender it. There's information we can talk about.
Okay.
Outside the presence of the jury and circumstances.
All right, ladies and gentlemen, we're going to take just a short 10-minute break. It's about 5 minutes till 3. We'll try to get started about 5 minutes after 3. Please keep in mind all those instructions you were given yesterday. If everyone else would please remain seated in the courtroom, you're excused for about 10 minutes. All right, let the record reflect the jury's outside the presence of the courtroom. So what is the issue?
Judge, the certified judgment for that evading arrest and detention has some other information attached to it that I don't think the jury needs to necessarily see. I didn't separate it out because it's part of that entire certified document, and I'm happy to take it out for the court. I'll let Mr. Wilson look at it. I've tabbed it here for Mr. Wilson.
Of the list of priors. No, I agree that shouldn't go before the jury at this time, Your Honor. But at this point, even if offered, I would object to the relevance as that it hasn't been proven to be a judgment related to this defendant.
I'm going to get to that relation to the defendant in just a second.
So other than the objection, Mr. Wilkerson, you are in agreement, it looks like, with the first. Technically, it's 6 pages. That is 5 pages make up the judgment. The last page shows that it's a certified document for those 5 pages. And then we've got that tab that has all the other information. And so, notwithstanding your objection, which we'll talk about in a minute, just with regard to what is being offered, you agree that we can remove that back part and just go forward with the 6 pages?
Yes.
I'm gonna.
Should the evidence be proven?
Yeah, no, I'm just for now, that way we're talking about State's Exhibit number 10, which is a 6-page document.
I'll get that surplus.
There's both. So with regard to proof before it is introduced, Mr. Coleman, is there some other testimony or?
I have a self-authenticating certified criminal history record from the state, the Texas Department of Public Safety, that has the defendant's identifiers that link back to this judgment, in particular a SID number in his name as well. And there are other identifiers in the certified criminal history from DPS that includes actually a photo of the defendant, his date of birth, his FBI number, among other things, Judge.
And that's the part that obviously the jury would not see.
Well,
but
what I have done is I have the complete certified copy from DPS that has his entire criminal history, and I've prepared a redacted version that only has the evading arrest information in it.
I haven't had an opportunity to examine the charge.
Well, I think we put the certified criminal history in the discovery, but this is a redacted version. I'm happy to show it to you. It only has the evading arrest. Everything else has been redacted out. Have the complete certified criminal history, but I can see that.
So is that marked as states,
That should be, my plan is marked as 11.
okay.
I think yet. And I'll take my post-it notes off.
So we've got 10 is the certified judgment, 11 is the certified records from DPS with the everything redacted other than the jurisdictional underlying offense of evading arrest or detention with previous convictions, correct?
Yes, sir.
Mr. Wilkerson, with regard to states 10 and 11?
We still object, Your Honor. These haven't been specifically tied to this defendant before they are introduced as evidence against him, not in the process, they shouldn't be introduced and then somebody testify, yeah, I think that's the defendant sitting there based on an old picture where he has a shaved head and doesn't really look like in the picture, Judge. We would object.
It looks just like him in the picture for the record. Other than the hair, there is a picture. It's a thumbnail size picture. It is definitely, in my opinion, a picture of the defendant. If you'll show them both to me again, please. Hand me both 10 and 11.
There's also a city number.
Because they are, and I understand, I guess, Mr. Coleman, so because they're certified, obviously these are self-authenticating. The part that your objection is that they aren't tied to Mr. Johnson here today.
That's correct, Your Honor. The identity of the defendant as compared to the identity in the judgment and any certified criminal history, which also includes on the last page lines showing where it looks like prior records had been, but in any event has not been tied to this defendant by any fingerprint evidence or any other method in which it could be established as relevant to this defendant.
I would like to point out, Judge, that the indictment lists the defendant's name and date of birth, same date of birth, name and date of birth that appears in both of those documents, or at least in the certified criminal history letter. And Judge, if I may add that any additional objection would go toward the weight and not the admissibility of that of the evidence.
All right, so based on the information that is in State's Exhibit number 11, which has the defendant's name, Romeo Randolph Johnson, on the front page. It says black male or BM, date of birth 1988, excuse me, which is the same date of birth that is listed on the indictment in this case. The second page has more information, but specifically it has that picture, which I'm able to see for myself that picture, in fact, matches Mr. Johnson, who is sitting here in the courtroom today, but for different hair in that picture. It has the same date of birth listed on that second page of that as well. And then third page goes on with the same tracking number, same name, Romeo Randolph Johnson, with the prior felony offense of evading arrest or detention with previous convictions as listed in the indictment that we have here in clause number 25, DCCR 1626. Then with regard to that information, and you go to State's Exhibit number 10, which is the actual judgment prepared here in Jefferson County of conviction, has the same name of Romeo Randolph Johnson. It has the same disposition date on the judgment that is listed on the DPS criminal history that is also listed in the indictment. All three of those have the same disposition date of April 13th of 2022. So for all of those reasons, I think the identity, even without the thumbprint, which Sometimes it's not required. Obviously, if there's a thumbprint that can be identified, that is used, but other identifying factors can be used in introducing items like this. And so I'm going to overrule your objection, and states 10 and 11 are admitted.
What we would ask, Your Honor, is with regard to states 11, that the court seal that for having admitted states 10 for its own, for purposes of proving up the judgment, and then seal 11 as a court's exhibit that you based your ruling on the demographics and whatnot set forth. In that, we think that there's if it's only to show that it is indeed this defendant, and the court's making a ruling based.
Well, if the problem is, if there's argument about the weight of the judgment to the jury, then I think it would be important to have both in. I'm not going to seal something that I've admitted as a state's record as a court's exhibit. So states 11 is admitted and states 10 is admitted.
We would ask reconsider only to the demographics set forth that include tattoos and things of that nature. To the height, weight, and the photograph, obviously, we have no issue with that being put before the jury.
I mean, the list of tattoos and scars on here are not specific as to what the tattoos are. It just says that there are tattoos on different places. So no, I'm not going to do that. So there's 10 and 11. So
That's all I needed to address, Your Honor, off the record.
okay, all right.
I should say outside.
Outside the presence of the jury. In anything else before we bring the jury back in?
No, Judge.
Not from the defense.
All right, we can get the jury back in, please.
You want to win? Me?
Let the record reflect the jury seated, state's attorneys present, defendant, defense counsel present. Mr. Coleman, you may proceed.
Thank you, Your Honor. At least for the benefit of the jury, I'd like to point out that state exhibits number 10 and 11 have been admitted into evidence. Number states 10 being the judgment of conviction for evading arrest with previous convictions from Rule 13 to 2022, and a certified criminal history record from the Texas Department of Public Safety. At this time, Your Honor, the state will call Detective Lance Carmouche.
Detective Carmouche, please.
And how are you employed?
I am a patrol officer with the Beaumont Police Department.
And your training and background, what does that include?
I've taken numerous amounts of investigator schools, interview schools, homicide detective schools, drug schools, undercover work. Been doing it for about 18 and a half years.
And you're a certified peace officer in the state of Texas?
Yes, sir.
And your duties back on September the 14th of 2024, what did they include?
I was assigned to the Beaumont Police Department's persons unit. We handle all major crimes, homicide, aggravated assaults, robberies, things of that nature.
And as part of your duties, did you become a part of an investigation that involved surveillance video from Amigos Food Mart located on College?
Yes, sir.
Amigos Food Market College near Avenue D, is that fair to say?
Yes, sir. Avenue D.
Beaumont, Texas, Jefferson County, Texas, correct?
Correct, sir.
And the surveillance video that we're referencing, did you get an opportunity to review that video?
Many times.
And how many different camera angles are we talking?
I believe there is two.
Okay.
If I'm correct, I believe there was two.
Two different angles, but three separate videos from those.
Yes, the way the building is placed, one is kind of facing towards College Street and camera wise, and the other one's facing more towards the southern portion of the business.
And the events depicted on the video, did they occur in the early morning hours of September the 14th
Yes,
of 2024?
yes, sir, I believe so.
And we're talking about somewhere around 2 a.m., correct?
Thereabouts.
Thereabouts. So it's fair to say it's dark outside, the parking lot was dark.
Yeah.
The quality of the video, how would you describe the quality of the video for this jury?
10 being, the best, one being the worst, I'd say a 7 to 8.
And before we look at the video, please tell the jury what you saw when you looked at that video, just as a summary, briefly.
I was trying during my investigation that I was doing into another incident. I was pretty much watching, and in the video, I can see a defendant and another subject named Ethan Smith walking from Gilbert and Avenue D, which is basically one street south of College. They were walking towards the Three Amigos store. The defendant gets into a verbal argument with another subject. Brandis pulls out a firearm, is walking around, follows the guy with the firearm in his hand. And Mr. Smith, Ethan, he had to go and retrieve the firearm from the defendant and then told him to go to this car where his friend was going to drive him off. And once they got back to the car, he handed him his gun back, and then they drove off of College Street.
And the individual who possessed the firearm, were you able through your investigation to identify the person?
Oh, yes.
And who did you identify him to be?
Romeo Johnson.
Romeo Randolph Johnson?
Yes.
Do you see Romeo Randolph Johnson in the courtroom here today?
There he sits.
What is he wearing, please, for the
I
record?
guess it'll be black and white checker.
Your Honor, I asked that the record reflect that the witnesses identified the defendant.
The record will so reflect.
Now, we talked about the video. Let's, with the court's permission, I'd like to publish the video, please.
Sure.
Officer Carmouche, there's a screen behind you. It's more helpful. There's also a pointer. It's up to you, got the laser pointer. Orient the jury. What are we looking? What perspective are we looking from, and what are we looking out onto?
Okay, this road right here that goes north and south is Avenue D. This camera was inside the business of Three Amigos. There's a street over here that goes east and west. It's Gilbert Street. And this would be the parking lot on the west side of the business.
It's gotten hung up, Judge. I may need to restart.
Okay.
All right, Officer Carmouche, it looks like we got our technical difficulties worked out here. What is happening there on the right of the screen?
In this area right here by this kind of Winnebago looking car right here, right by it is this little short taqueria stand. Several people were there just that work for Mike's Furniture or just hanging about getting some food. And in that area at the time, I believe it was Mr. Johnson.
All right, that's on the left hand of the screen. What's happening on the right hand of the screen?
That would be Mr. Johnson's ride.
All right.
Out of there. Mr. Johnson is here with a white shirt and black shorts. At the time, he's currently in an argument with the subject back he's behind this pole here, but you'll see him walk this direction. There he is. He's in an argument with this guy, and Mr. Johnson's right there.
Let me interrupt, Officer Carmouche. For the purposes of the record, we're about 32 seconds into the video, and it's fair to say, well, how would you characterize the defendant's demeanor?
He looked angry.
All right, we're about 36 seconds into the video. What, if anything, jumps out or is distinguishable for you?
Right there, you see that's Mr. Johnson. He's holding a firearm in his right hand. While he's walking, and when he first was walking, he was walking straight on. And usually people don't do that unless they have something in their pocket because he's wearing shorts, so he's not wearing a holster. It's loose.
We're about 40 seconds into the video. I know it takes a little bit to kind of focus in there, but what, if anything, has become more apparent to you, if anything?
The firearm in his right hand. And the fact that he's approaching with the subject that he was having an argument with earlier.
You've watched this video a number of times, is that fair to say?
Very much.
And having watched the video, are you able to make out any distinguishing features of a firearm?
Yes, sir.
What are they?
And you can tell, in some frames of it, you can see the bottom of the firearm where the magazine well is. You can see in other angles where because he's walking, the slide action of it, you can actually see there where his finger is cupped in it, kind of like that.
This other individual, about 44 seconds into the video, what happens, or what do you believe happens based on watching this video?
That's objection, speculation, or
I'm asking what he believes happened based on watching the video.
Overruled.
You can answer, officer.
So this is Ethan Smith right here. I know him very well. He arrived with Mr. Johnson. He obtained the firearm from Mr. Johnson and basically said, "Come on, get out of here."
objection, hearsay, or
Overruled. You cannot say what he said or
Okay,
what you
sorry.
think he might have said unless
He's
it was.
he's making gestures to leave.
Based on your observation of the video, who do you believe has that firearm at this point?
At this point, it's Mr. Smith.
So it appears, based on the video and your testimony, that the defendant had the firearm initially. Then Smith gets the firearm from the defendant.
Correct.
Is Smith a fellow? Is he also walking and carrying that firearm in a manner that in your training and experience people typically carry firearms?
Yes, sir.
We're about 1 minute and 11 seconds into this video for purposes of the record. What is happening here, Officer Crumwich?
Mr. Smith right here is about to hand this over to Mr. Johnson with his right hand.
This being the firearm.
This being the firearm.
And again, and now I'm happy. What I'm gonna do is run this video back and just play it full speed without pausing so that you're benefit of the jury. But you've had the benefit of watching this video numerous times, correct?
Yes, sir.
And to the extent you can zoom in and focus, you've done that, correct?
Yes, sir.
And based on your training, law enforcement training, and having watched this video, did you form an opinion as to what, if any, object these two are trading back and forth?
Yes, sir.
What is that opinion?
Firearm.
What does that timestamp say at the very top up there?
I believe it says 1:47 and 37 seconds.
That's on, looks like 2024, September
Yeah,
14th.
September 14th, 2024. So.
What I'd like to do now, Officer Carmouche, I know we paused it a number of times. I'm gonna just run it back and just play it without interruption.
So.
Of course, permission, I'd like to publish these still photos. Thank you, Judge. States 3 through 8. Record, we're looking at State's exhibit number 3, and if it's more helpful to refer to the screen behind you, then please by all means do that. And if it's better to use an actual physical pointer, I think we've got a physical pointer, and the court will allow you to stand up and do that as well.
Whatever's easier.
All right. What, if anything, is distinguishable or that you think is noteworthy for this jury?
In his right hand, so his hand is cupped in here. Right here is where you can see the magazine well of a black pistol. You see this protruding, and that's this is firearm high as, and his fingers kind of looks like it's that, like his knuckle his trigger fingers, index finger, I'm sorry, is 4.
Closing State's Exhibit number 4. I don't want to characterize it for you, but is it a better angle, better shot, a more clear shot?
It's a different shot, same quality, but like before, here's the matte black magazine well, and here is the firearm slide.
For the record, this is State's Exhibit number 5. This is the individual who you identified as Ethan Smith. What, if anything, is noteworthy or remarkable for the jury?
He now has the firearm in his hand right now, clasping it in his left hand. Not holding it as well, most folks would think. It's like he's grabbing it like it's a normal kind of thing, kind of like just doing this.
State's Exhibit number 7. But you testified to that earlier about what happens or is about to happen.
Yes, sir.
What was that?
On the left is Mr. Smith. On the right is Mr. Johnson. In the right hand of Mr. Smith is the firearm. As they meet up together to part ways and leave, you can see him, Mr. Smith, hand Mr. Johnson the firearm, and then walk off.
And State's Exhibit number 8, is that handoff? Is it fair to say that handoff is depicted in State's Exhibit number 8?
Yes, sir.
I'd like to next direct your attentions to State's Exhibit number 9. Did you bring your copy of the transcript with you, State Exhibit number 9?
Yes, sir.
I would, for purposes of the jury, I think what I'd like to do is ask that we read this to the jury, and I'd ask that there is questioning by the prosecutor in that case, and then there's answers being given by the defendant in that particular court.
Approach, Your Honor.
Sure. Epstein.
Or at least an excerpt of the transcript from that proceeding.
Yes, sir.
What I'd like to do for purposes of publishing it to this jury is I'd like to read the questions that were asked of this defendant. And if you would be kind enough to read the responses word for word of the defendant from that court proceeding, please.
Yes, sir.
My question will be real pointed. I'm going to either ask you yes or no questions.
Yes, sir.
Or I'm going to ask you questions that require just a very specific answer. And in this question, I am asking you simply, who were you angry with?
A fellow that I was talking to, I guess you would call it his merchandise, he called it.
Okay, all right. Thank you, Mr. Johnson. And you would agree with me that you were pretty animated, pretty worked up, yes or no?
No, sir.
You weren't?
No, sir.
Okay, if that's your opinion, that's fine. What did you do with the gun that you were handed there at the Amigos parking lot?
Gave it back to who the gun belonged to.
Okay, the owner of the gun? Oh, excuse me.
Yeah.
The question was, okay, and then,
The owner of the gun.
okay, did you give it back to him on the video? Can we see that if we replay that video?
Sir, you should be able to.
No, yes or no? Remember, it's gonna probably always be yes or no, or a short answer.
Oh,
If we were to replay the video, Mr. Johnson, will we be able to see you give that gun back?
I'm not sure, sir. If you look at it
Okay,
you have cameras at the angle.
objection, non-responsive, and the court in that case responded with just answer the question very specifically. And the question followed, thank you, Mr. Johnson. I will move on, sir. When did you give it back to that person?
He went and got something for me. Brought it back to me.
When I asked,
When he come back to the car,
excuse me, Mr. Johnson, I'll make you a deal. I won't talk over you if you don't
I apologize.
Talk over me. I apologize, sir. No, excuse me, that's you.
Yeah, prosecutor, I apologize. Yes, sir.
When I say when, all I want is a time or a time frame.
Yes, sir.
Please, when did you give him the gun back?
When he came back to the car.
And what time frame would that be?
Oh, I'm not sure, sir. I couldn't pinpoint you down a.
A matter of minutes?
Yes, sir. Matter of probably not even, probably a minute.
All right. The person that gave you the gun that you gave the gun back to, what was his name?
Ethan Smith.
So if I call Ethan Smith as a witness, Ethan Smith will essentially give testimony that they essentially say the same thing you just said.
Sir, I'm not sure what Ethan would say.
That's a fair point. Thank you, Mr. Johnson. And I think lastly, I'd like to walk through State's Exhibit number 10, the judgment for the felony conviction, the prior felony conviction for evading arrest with previous convictions. Do you have a copy there with you?
Yes, sir. I have a highlighted copy.
All right. And is it an exact copy, or at least the exact copy of the first page of State's Exhibit number 10? May I approach you, sir?
Yes, sir.
Feel free to compare the two of those.
Get one. Yes, sir.
Who is listed as the defendant in that case?
Romeo Randolph Johnson.
And the court in which that judgment was entered or rendered?
In the criminal district court, Jefferson County.
What date was that sentence imposed?
April 13th, 2022.
And the offense?
Evading arrest with previous convictions.
And the punishment?
Confinement in the institution of division of TDCJ for a term of 4 years.
So is it fair to say that if on April the 13th of 2022, this defendant received a 4-year sentence, if he possessed a firearm on September the 14th of 2024, it would be within the 5-year period after being confined in this judgment and or being released to parole?
Yes, sir.
Based on your law enforcement training and experience, based on your review of the surveillance video, based on the defendant's admission under oath. And one other thing on that admission, let me ask you this. I don't know if you counted them or not, but how many times, if you recall, was the term gun mentioned in that transcript?
I'd have to look back, sir. I don't know.
Is it fair to say it was mentioned several times?
Yes, multiple times, sir.
At any point, did that defendant say, whoa, wait a minute, what do you mean gun?
It didn't sound.
Objection, best evidence, Your Honor.
Overruled.
At any point during that exchange, did the defendant say, wait a minute, that was a pellet gun?
No, sir.
At any point, did that defendant say, hold on, that was a BB gun?
No, sir.
Based on that video, the sworn testimony of the defendant, and your law enforcement training, did you form an opinion as to whether or not an offense or offenses have been committed this defendant on September the 14th of 2024?
Yes, sir.
What was that offense?
Unlawful carrying a firearm by a felon.
And that's in violation of chapter 46.04 of the penal code?
Yes, sir.
Did you prepare a report, at least detailing some of your involvement in this case?
Yes, sir.
And did you review that report prior to testifying today?
Yes, sir.
And did it help to refresh your recollection about the events?
It was fairly stuck in my head and I remember it quite well.
That's what you said.
Thank you, Mr. Coleman. Mr. Wilkerson?
Your Honor. Detective, how did you know what Mr. Johnson said
At what time, sir?
in a prior proceeding?
At the transcript and
You sure about that?
after.
You sure about that? That it was based on the transcript?
That was one of the things, yes.
One of the things, what I asked you was, how did you know that's what it said?
At the end of the proceeding, I found out,
Found out,
was told,
was told
the deed.
by someone who is not present to testify, correct?
Let's be the prosecutor.
So you heard from the prosecutor that the defendant, I guess, prosecutor would have characterized it as made an admission during testimony in that proceeding?
Yes, while under oath.
I see. And you immediately on October 14th completed an offense report, correct?
Yes, sir.
In your offense report, you didn't mention anything about having been told that this statement was made, did you?
Nope, no, sir.
Nope. And you didn't mention any details of the statement, did you?
No, sir.
And on October 15th, you submitted a complaint signed by yourself as the affidavit, correct?
Correct.
All right. And on September 20th, first witness, Your Honor. Sure. I'll show you what's been on. And admitted, State's Exhibit 9, this record was prepared on September 20th, correct? Or, I'm sorry, on October 20th, correct?
Not sure. This be the reporter's
At the
certificate.
very end, yes, where it's certified.
20th day of October 29th.
Right, so this wasn't prepared until after you had already submitted your offense report and your complaint. That was signed also by the district attorney, correct?
I'm not sure when they signed it, but yeah, I believe it was.
Oh. First witness? Sure. Would it refresh your recollection, looking at the complaint that you submitted?
In dates in here somewhere? Where? Yeah, October 15th, okay. Sorry, great.
Yeah, that was October 15th, correct?
Yes.
So is it the case that you were instructed to prepare an offense report and a complaint?
It was always an option to file that.
Always an option. Well, let me ask you about that. Always an option. Your underlying investigation where this video stems from, there was nothing in that report that you completed mentioned about this defendant ever being in possession of a firearm, was there?
One more time, sir. I'm sorry.
Let me try and clarify the question. The scene depicted here in the video that's been admitted, in this and the underlying allegations of this charge, in that case, or in the underlying case that you were investigating, charges against this defendant for unlawful possession of a firearm by felon had never been contemplated or weren't contemplated by you when your offense report was submitted, were they?
It was contemplated, and we sent to Dave's office, and they have their prerogative of when they send to grand jury.
When you say it was contemplated, usually when a case is submitted to the DA's office, the allegations or the specific charges for which any person was arrested or for which an indictment is being sought are set forth in that offense report, are they not?
You're asking if it was in another offense report?
Correct.
No, because I didn't have that charge in that.
So when you say it was always an option, there was something that triggered an instruction to you to prepare this complaint?
The decision.
A decision made by someone else, correct?
No, sir. I actually had the decision myself. And
you weren't instructed to do this?
No, sir. That was an option that was always on the table.
My question was, were you instructed to prepare this?
As I said, no.
You were not instructed to prepare this?
Yes. Out of like nowhere. Like it's always was an option.
Objection, non-responsive. If it was always an option, why did you only prepare it on October 15th or 14th, the offense report, on October 14th of 2025, when this event occurred in September 2024, and you had been in possession of that video since your investigation that led to the confiscation of.
Y'all come up for a second. 4, we'll get started at about 5 minutes after 4. Please keep in mind all the instructions you were previously given. If everyone else would please remain seated, you're excused for about 10 minutes. All right, let the record reflect the jury's outside the presence of the courtroom. I'm at this point going to instruct you. Everything that you're asking has been asked and answered. The continued belaboring of it is, in my opinion, an attempt to get Detective Carmouche to say something that I've instructed everyone not to say. And it's extremely frustrating because I have granted a motion in limine. We had a specific conversation, and continuing to do that and ask those questions, he's not allowed to answer them in the way that I have instructed prior. And so you are going to stop with that questioning. You've got it out that there was some time frame for whatever reason, but we're not going to get to some aha moment where he says what he's not supposed to say. And I appreciate that from him, but we're done with that line of questioning.
All right, I need to make an offer of proof, Your Honor. I don't know if you want to do that now or after this witnesses.
With regard to what?
With regard to the objections for 107, specifically optional completeness and the.
No, we're not talking about that right now. We'll do that.
Prejudicial, okay.
Yeah, we're going to take a break and then we're going to complete your questioning. And then when we don't have a jury waiting on us, we'll take care of whatever we need to either before, after, or during breaks.
One thing, Your Honor, if I may, I could ask the court maybe consider the question by this defendant about the underlying report and the fact that what it didn't mention, the underlying report did not mention a firearm. He's talking about the report for the other offense. I don't know that it necessarily opens the door.
I reworded it so that.
No, this is why I'm frustrated right now, because the report you're talking about is the report that we're not supposed to be talking about, the underlying offense that we're not supposed to be talking about, that I specifically said. So we're not going to go into anything else at this time. Let's continue with your cross-examination when the jury comes back in. We're done with that line of questioning about why he did or didn't do anything at a certain time frame, because all that's doing is an attempt to elicit something that I have already ruled on. So we're going to take a short break. We'll be in recess. All right, let the record reflect state's attorneys present, defendant and defense counsel are present. And so with regard to state's exhibit number 9, Mr. Smith.
Judge, state's exhibit number 9 is what was admitted, had the 3 pages you did not want on. I have made a copy of that with just pages 4 through 7, and we have labeled that state's exhibit 9A. 9 will be for purposes of the record only. 9A will be what will be given to the jury.
All right. Thank you very much. So 9 is record purposes only. 9A will be what is admitted for the jury. Anything else before we bring the jury back in?
That was it. Not from the defense, Your Honor.
All right, you can bring the jury back in. Let the record reflect the jury seated, state's attorneys present, defendant and defense counsel are present. Mr. Wilkerson, you may proceed.
Detective, did you review state's exhibit 9 prior to testifying today? The transcript?
Transcript? Yes.
Did you review the transcript of the entirety of this defendant's prior testimony?
No, sir. I only read the excerpt.
Is it fair to say that the excerpt is a selective portion of that prior testimony?
Yes, sir.
Part of a much longer exchange?
Yes, sir.
Questions, they aren't typically asked in a vacuum, are they?
No, sir.
All right. And have you, how many trials would you estimate you testified in?
Maybe 35, 30 to 40, somewhere around there.
During all that time, you've been cross-examined any number of times. Is that accurate?
Yes.
All right. You ever had something that you included in your offense report or something that you said taken out of context?
Yes.
And did that create a misleading impression?
Yes.
Would you agree that it's important that misleading impressions not be created?
Yes, sir.
Talking about the the gun, as it's identified, at least in the defendant's testimony, you don't have the gun, right?
No, sir.
Do you know what the make and model of the alleged firearm is?
I do not believe I do.
Have you ever seen the alleged firearm be discharged?
Not seen a discharge done.
So how are you certain that it is a firearm?
Since the training that I've done on firearms, both in the Marines and 18 years as a cop, 2 combat tours, all of them.
And you're able to discern that from that very grainy video.
Yes.
Are you still detective or patrol only?
I'm back on patrol.
Back on patrol. All right. So you testified, you characterized an argument between the defendant and another individual on that video. Is that accurate?
Yes.
You weren't there for that exchange, were you?
No, not personally there.
And the video footage that was presented here, in fact, you point out that the defendant and this other individual that there's an alleged conflict or argument with are behind a column. Is that accurate?
Behind a column?
Yes, behind
the bar. I was referring to the bar in the camera feed, I guess.
Oh, is it fair to say that you don't see an actual argument take? Well, there's no audio with the video footage, is there?
You're correct.
So your characterization of an argument, that's your characterization, right?
Mm-hmm. To interviewing other subjects, yes.
Oh, so you're basing that on hearsay?
Corroborated with from what I could see on video.
Well, but the jury sees the video for themselves, right? Okay. So your testimony is based on hearsay and not based on something that you can actually observe in the video, right?
That's what we call this.
Yeah. All right. And John asked that the jury be instructed not to consider testimony about an argument.
That's overruled.
All right. The argument that you were testifying about, did you identify the gentleman at the end of the video? That gentleman, is he walking up to the defendant in this case?
Which gentleman?
The person that you're alleging was in an argument with
Is
Mr.
the subject
Johnson.
in the blue shirt?
Guy in blue jeans walking across the parking lot at the beginning of the video.
Police with glasses.
Just so we're all clear on the same thing. All right. So as this car arrives, this blue car arrives, that you say is Mr. Johnson's ride, there's a gentleman in a black shirt and blue jeans walking across the parking lot, correct?
Yes, sir.
Is that the gentleman that you're saying was in an argument with this defendant?
He was one of the people, yes.
One of the people. So now the argument involves multiple people.
When I spoke with him, he told me that
Objection, hearsay, Your Honor.
Spoke with who?
it was a guy who was running the talking to me.
Overruled. I mean, sustained. You can't, talk about with hearsay. Thank you.
Was it an argument between this defendant and someone else, or an argument between a bunch of people? Per your investigation?
Honestly, it appeared just an argument.
Just an argument. So we don't know the context of an argument. We don't know how many people are involved. Correct?
It'd be more than 3. I know that.
And is this same individual the individual that you're saying that Mr. Johnson's threatening or coming behind with a firearm in his hand? That individual who just walked across the screen, is that the same individual?
Yes, the one I was walking away, looking backwards, yes.
All right. Now, you also testified that it looked like Mr. Johnson took a firearm out of his clothing. Is that depicted on that video that we just watched?
Is him taking it out on the video?
Yes.
No, sir.
Okay, so you don't know where the firearm came from.
This person.
How do you know it was his firearm? He testified it belonged to Ethan Smith, right?
He was still in possession of it.
How do you know it was his firearm?
You do not know.
How do you know that it was on his person prior to the video?
Well, it was on his person when he was walking with it in his hand. Possession.
I'm asking because you provided a characterization of this exchange to the jury, right? I want to ensure that the jury are considering only the facts in front of them, not your characterization of those facts.
Yes.
Again, the question is, again, you would agree that it's important not to mislead the jury, correct?
Correct. Everything should be transparent.
All right. Other than Ethan Smith, were you able to ascertain any other, I believe you said you spoke to the individual depicted. What is his name?
I do not have it with me at this time.
Do you have any other names?
That would be it from there.
Guy who owned the taco stand.
He did not want to speak with him.
Okay. So, aside from the person that the defendant testified on the gun, you can't give us the names of any witnesses from that scene. Is that correct?
Only people I recognize was Ethan Smith, Mr. Johnson, and the other subject. I don't have his name at this time.
Okay. Now, in this same video, oh, I read it wrong. Sorry. All right. What I'd like to do now, well, if I can get my whole clock right. All right. What I'd like to do now is play through this video, and I'd like for you to identify where in the video the exchange that you're identifying as having taken place in State's Exhibit 7 occurs.
The exchange between him and Ethan Smith?
Yes. And by him, we mean.
I'm sorry, Mr. Johnson.
Right. Okay. Before we get there, let me stop you because you also gave testimony that Ethan Smith had to go get the gun from the defendant, right?
Yes.
Here in this frame, we can see the defendant still beside the tire of the vehicle where Ethan Smith is approaching, correct?
Correct.
All right.
And then somewhere from there, in that area.
All right. So somewhere in there is the what you say is the initial exchange where the firearm is given to Ethan Smith.
Yes.
All right. And that firearm that you say is given to Ethan Smith, or that gun, is that in Ethan Smith's left hand at present?
Yes.
All right. All right. So you're saying that exchange is where this defendant is taking the gun. That's
Retrieving that, yes.
regarding this offense. Did you interview Ethan Smith?
Yes, sir. Briefly, but he was under the influence and inside hospital.
Your offense report, is it fair to say that it's a terse five-line paragraph?
Yes.
Nothing about Ethan Smith is mentioned in this report.
No, sir. Just the back.
Approach, Your Honor, very briefly.
Sure.
Yes, witness.
Briefly, thank you, Your Honor. Officer Carlucci, is there anything misleading about the question, what did you do with the gun that you were handed?
No, that's all.
Regardless of whether or not you have any firsthand knowledge of what was said during that court proceeding, what was testified to in that court proceeding, do you have any reason to question the authenticity of that transcript?
No, sir.
possession of an item, particularly in this case, a firearm, what is your understanding of what that consists of?
Possession is taking care, custody, and control of an object. No timeline on it, anywhere from the second it touches a person to them having it to an hour to 20 minutes to as long as they have it.
Care, custody, and control, no matter how brief,
No matter how good.
how slight. Now, when you're making a report or swearing out a complaint, are you as a certified law enforcement officer allowed to rely on information that you deem credible and from a credible source?
Yes.
And your understanding of how charges are referred and how they are brought to the district attorney's office. Let me ask you this one. Prosecutorial discretion. What does that mean to you?
Basically, it means as a detective, I would get and make a case, put it together, fact find. And then from me, it goes to the district attorney's office. And then they have their own prerogatives on how things are kind of done, grand jury wise, all the way up to prosecution.
In other words, it's not unusual for law enforcement to refer one charge and for the district attorney's office to opt to prosecute either a lower or higher charge.
Objection leading.
I'll ask you.
That's, go ahead.
In my experience, that's been normal.
And also, does the grand jury play a role in that? In other words, you as law enforcement can refer a particular charge over, but a grand jury can opt to indict for either a higher or a lesser or even a different charge out of the same occurrence, correct?
You're correct.
That's the mistake.
Anything else, Mr. Wilkerson?
Yes, Your Honor. You testified that you're not aware of any time frame associated with unlawful possession of a firearm. That possession, though, it has to be more than just fortuitous, correct? It can't just happen by chance, right?
When that is, how do you mean?
Well, do you know then, do you know if the law requires that possession of a firearm actually, in terms of unlawful possession thereof, actually be more than just possession that is by chance or happenstance?
Judge, I would object to this line of questioning as it is misleading to this jury about the legal definition. I've never heard that to being a part of the definition for care custody. Something about fortuitous. I never heard.
Response?
I forget the case I was reading last night. Go back and we can.
Sustained. Okay.
There are mens rea elements of possession, unlawful possession of firearm, aren't there?
Yes.
And what are those?
What is mens rea?
I'm sorry?
Mens rea.
Yeah, the required state of mind. What's the required state of mind with regard to this offense?
Knowingly, intentionally.
Okay. And obviously, you were asked specifically about prosecutorial discretion, so the DA's office, just to be clear, obviously in the very brief transcript that's been entered into evidence, is questioning this defendant about that video, correct?
Correct.
And is it fair to say that the DA's office obviously had that video in their possession for a long time prior to the prosecution here?
Objection.
Your Honor, the state was specifically asked about prosecutorial discretion. The state asked.
Hold on.
You were asked about reliance on a credible source. Is that correct?
Yes.
In this particular instance, is that credible source that you relied upon the state's attorney?
Yes.
Past witness. I have no further questions for this witness, Your Honor.
Any objection to him being excused? Subject to recall.
Subject to recall and additional questioning outside the presence of the jury.
So if you'll just hang around for a little bit, there's a few things we'll take care of after, but you're excused.
Yes, ma'am.
Thank you.
Your Honor, this time state of Texas rest.
All right, thank you, Mr. Coleman. And so let's do this, ladies and gentlemen, since the state has rested, we'll go ahead and take our afternoon break. We've got some legal stuff to take care of. Also, we'll make sure that we work on that court's charge that we'll get to you at some point tomorrow. and have that prepared so we don't have to have hopefully too many times where you have to step out and wait around for us tomorrow. All right. So keep in mind all those instructions that you were previously given. We'll get started tomorrow morning at 9 o'clock. And if everyone else would please remain seated, y'all have a good night. We'll see you tomorrow morning at 9 o'clock. All right, let the record reflect the jury's outside the presence of the courtroom. In just a second, we'll get to Officer Carmouche back in. So I want to ask before we go too far on your request with regard or your objection, Mr. Wilkerson, with regard to the transcript and the discussion about other things in that transcript, and that's just a small portion of it, and optional completeness and all of that. Is there somewhere that you can point to in the transcript that you believe is relevant to either counteract or counter what he said in that portion? Or is it just a general objection that the entire transcript would somehow be relevant? Because I'm willing to, if there's something in there that you think he said that would be relevant, that shows that that portion was potentially, either he was talked into saying it or whatever you want to say. If there's some specific statements, then just like I allowed the state to do it, we can discuss that.
Judge, I don't have the entire transcript in front of me to review, and I'm right now, just off the top of my head, the specific issue, I cannot. There was one line, but I need an opportunity to review my notes because obviously I did a lot of research on this matter in reference to the notes I had from the prior proceeding. And so I don't have the definitive line right now, and I don't have a transcript where I would be able to offer that excerpt from the transcript.
You guys were all given a copy of the transcript, correct?
Oh, no, the record will reflect that when I received that transcript, I attached it to a notice of my intention to introduce that transcript. Don't hold me to this, but it's been
the entire transcript.
No, I only requested the excerpt.
Okay. So was the prior transcript requested?
No.
Okay. Well, if you don't have something specific and that wasn't requested, then there's nothing I can do about that. So what do you need to put on the record before we break for the evening?
I need to put on testimony from Detective Carmouche about specifically about the underlying.
Mr. Wilkerson's.
I'm sorry, specifically about the underlying testimony, the underlying case.
To what end? For what purpose?
To preserve the record for a potential review on appeal.
For which objection?
For optional completeness and prejudicial value. Again, the court obviously admitted evidence. It has since modified that evidence, but the witness also referred to the defendant when being questioned about the testimony that was provided. I took that to mean the defendant in that proceeding obviously identified in the entirety of the exhibit that the state sought to introduce also as defendant in that proceeding. And so the fact that so the voluntariness of the statement, because of the context in which it was given, I believe is an issue. And so, Judge, I need to put all of that on the record with regard to the context under which this testimony was given, what was being discussed during this testimony that was provided by this defendant, the underlying nature of the case, all of it, Judge.
Hey, we're not going to do all of it. I need a specific objection. I need a specific part of the transcript. If you want a rule of optional completeness, then I've already denied that because that's the entire transcript of the murder trial. That was an acquittal that I've already said we are not going to get into in this trial. The Court of Appeals, when they're reading this, will be very clear, I think, of what my ruling is, right or wrong. I've now said it multiple times, so hopefully I'm right. Because if not, there won't be any discussion of whether or not I really meant what I said. So let's take that off the table then. We have talked at length about the underlying or the other, it's not underlying, the other offense, the murder that he was acquitted for, and that I have found that that is not relevant. You have objected. My question is, what does Detective Carmouche have to add other than to preserve your appeal with regard to me saying we're not going to talk about that?
So again, What I was talking about in terms of completeness was, and voluntariness was context in which that testimony was provided, right? Obviously, in that case, so there's testimony I need to be introduced as to whether this defendant waived his Fifth Amendment right against
So
self-incrimination.
how is Detective Carmouche have any of that information because he wasn't here in the courtroom? I don't think that's the appropriate way. I understand what you're trying to do, Mr. Wilkerson, but I don't. Detective Carmouche was a witness in that, but he was not in the courtroom when your client and you were the attorney. And there, if we need to potentially on appellate review, they can request, or that appellate attorney could potentially request the transcript from that murder trial. And I have no doubt that in that trial, you as Mr. Johnson's attorney discussed him taking the stand or not. I don't know 100%, but it's very likely that we put something on the record with regard to that because we always do. And whether or not Mr. Johnson was taking the stand freely and voluntarily and after you had talked with him and everything else. And so I don't see Detective Carmouche being able to add anything other than what his testimony was at the trial, but not what any underlying, whether Mr. Johnson took the stand voluntarily. It wasn't a detective interrogation. It was in a trial where I'm pretty sure I admonished him, you admonished him, we had the whole conversation on the record, and he chose to take the stand. So I don't think Mr. Detective Carmouche can help with that. So is there anything else that you feel like?
I'd still need to question him about the being patrol instead of a detective at present.
If I could respond to that, Judge, there's nothing in Officer Carmouche's testimony that would. In other words, the video stands and speaks for itself. The transcript stands and speaks for itself. The transcript has nothing to do with the truthfulness or the veracity of Carmouche.
No, I don't disagree. But I do think that if there is some issue that Mr. Wilkerson's entitled to that, and depending on what it is, the jury could potentially be entitled to knowing that information. And then the argument that you just made would be the argument to the jury. Not necessarily an argument for us not to have that conversation. So if you can get Detective Carmouche or Officer Carmouche back in, please.
Carmouche, we have discussed the fact that at the time of the underlying investigation, that you were a detective with BPD, is that correct?
Yes, sir.
You are now a patrol officer, is that correct? What were the circumstances under which that change took place?
Okay. The job of doing that is incredibly hard. It's hard on the family.
No, I'm sorry, is this being broadcast? I'd ask that this portion.
Okay. Anything else we need to take up before we break for the day?
Did I take a look at the charts? There's some couple items.
Let's do, we'll kind of go off the record and deal with some of that this afternoon, just kind of informally, and then any issues that we have, we can put on the record in the morning. I do want to have it prepared as best we can, depending on tomorrow. So Mr. Wilkerson, obviously you probably need to discuss with your client whether he wants to take the stand in this trial. Do you anticipate any other witnesses?
I do not, Brian.
So what I'd like to do is for you guys to visit this afternoon. Y'all can go back in the jury room, take your time, visit about that. I'd like to have that information today so that we know what we need to stay and do or not do based on timeframes tomorrow. All right. So we'll take a break while y'all do that. Anything that you need to put on the record after that discussion, we'll get that taken care of as well. All right. Court will be in recess. Okay. Let the record reflect, state's attorney's present, defendant and defense counsel are present, jury is not here. And so, Mr. Wilkerson, you've had an opportunity to visit with your client for 15 or 20 minutes. And what's the status?
Judge, I do anticipate him testifying tomorrow. I also anticipate briefly recalling Officer Carmouche. Okay. All right. So we'll get started with that at 9 o'clock.
So depending on testimony, I did a little bit of just looking at the section for UCW with regard to lesser offense. There's some very specific criteria in order for that to be an offense. And so take a look at that, if you would, please, so that you're prepared to either argue that those criteria have been met or not with regard to the evidence in this case.
So what I understand what the court's saying. What I would say initially, and I understand there has to be some bad act for it to be unlawful in the first place. So I do get that, but the jury could not believe that the defendant, in theory, the jury could not believe that defendant's convicted felon. So
No, it's not that. It's very specific with regard to if a person commits the offense, if the person intentionally, knowingly, or recklessly carries on or about his person a handgun. And then number two, at the time of the offense was either younger than 21 years of age, which the defendant is not.
Or engaged. I'm sorry,
No,
Judge.
or has been convicted of an offense under, and there are 1, 2, 3, 4, well, 5 actually, specific instances where he had to be convicted of, it was assault, I think terroristic threat, maybe deadly conduct. But if you'll look at those, because if you don't get past one of those as a prior conviction, then you don't get there. So, Mr. Coleman, check criminal history. I think they've looked and don't see anything where he's been convicted of one of those, but if you have a different reading of that, we can talk about that tomorrow. But I think that's the issue, and that's 4602 A to big B is the one kind of that we've got to get past, I think, on what the prior conviction was. Okay.
And then Judge, just to preview a little bit about the voluntariness issue, what I anticipate asking Officer Carmouche about is whether or not when a suspect or a person of interest is interviewed, if they're typically advised of what they're being investigated for with regard to any statement that they provide. And so that's really just the kind of context in which that'll be framed. So
I don't think this was in an interview, Judge. This was in a trial.
Correct.
That wouldn't apply. And Miranda warnings say any statement you use can be used against you, which he chose to testify in that trial.
With the advice of counsel.
Under advice of counsel.
Except they don't know at this point, allegedly, that it was even a trial. So they don't know the context that this.
Well, and they're not going to know.
But
they're not going to know. And so they do, if it's a trial, like I mean, I already kind of used that example earlier, that it was not an interrogation. And so voluntariness of his testimony is, in my opinion, cleaned up by that trial's transcript, which I presided over the trial. You were his defense attorney. Mr. Coleman was the state's attorney. It wasn't that long ago. All have independent recollection, just like today, that you had an opportunity to visit with your client. And after that, he made the decision based on y'all's conversation, whether it was with or against your advice, he made that decision to testify. And so I don't know that that Officer Carmouche would have anything to add, or why an interrogation. And I understand what you said before, also.
I'm only trying to get the jury to understand that when somebody provides a statement, a custodial statement, they are typically advised of what they're being investigated for. I'm only trying to get the jury to understand that the statement that was made, he wasn't anticipating anything about.
Well, I don't know that was let me think of how I want to say this, because I don't know that not anticipating that a charge for being a felon in possession of a firearm was a very far reach when you're on trial for murder. You admit to holding it or having it. It's on video. I don't think that's something that would be so far out of the realm of possibility for you, obviously, as an attorney, but for your client as well. And so I just don't see how discussing that with Officer Carmouche, with how an interrogation takes place, gets us anywhere, because also that gets us to potentially what he was advised of and what he was on the stand or being questioned about. And again, I don't believe that goes to the relevance of whether or not The simple question in this trial is, was he legally in possession of a firearm? And was he previously a convicted felon? Those are really the two questions that the jury have to answer. So, well, if anything changes after your client's testimony, then we will, we'll go there and I may reconsider that. I also want to make sure, that you discuss with Mr. Johnson. And Mr. Johnson, you've heard me loud and clear, probably a dozen times at this time, talk about what we're not going to talk about, right? And so, I want, you don't get in a criminal case to say something you're not supposed to, and it causes a mistrial or anything like that. If you say something you're not supposed to, then that's going to open the door for probably a whole lot of other things that potentially could come in. So y'all just talk about that and make sure everybody's on the same page and you're aware that if you feel like at some point tomorrow during his testimony that some door has been opened or it becomes relevant what that underlying offense was and the outcome, then I would want approach the bench outside the presence of the jury.
The court asked or inquired earlier about other portions of the transcript that might be relevant. And I believe that the discussion as it relates to the defendant testifying about, not using guns, that guns aren't his thing, that he's old school, that he uses fists.
So here's the thing, it's not my job and it's not the court reporter's job to find all that. The transcript has not been prepared because it was not requested. And so you can, obviously, Ms. Tanner cannot get a whole murder trial transcribed between now and tomorrow morning. So I'm not going to ask her to stay here and do that for the next 12 hours. But so if there's something that you can point to specifically or get close to for her to look at, she might be willing to do that. But again, it's already 5 o'clock and that hasn't been requested. So.
Just for the record, I'd like to point out that I gave notice of my intention to introduce this excerpt from the transcript back on January the 16th of 2026. Attached to that notice was the excerpt, and if Mr. Wilkerson had a need or felt that there was a need for additional portion of the transcript, you certainly had ample time to request.
Obviously, the defense contemplating being able to discuss the characteristics of that testimony and the nature under which the questioning took place. The relevance, I think, will become additionally clear based on the defendant's testimony associated with the context of whether or not that is indeed a firearm he's holding. But so I'll talk to the reporter judge.
Okay. All right. Anything else before we break then?
No, Judge.
Anything else?
Nothing else. You're right.